has become infructuous, my lords. I may be permitted to withdraw the writ petition.
Writ petition 25801 of 23.
ikkade
What
irodi
is your name?
sir.
Learned educated miss. What's your good name?
Bhavana Patil.
Bhavana but for learned Abhishek Malipatti appears to state that the writ petition has become infructuous. He files memo of withdrawal dated 9/7/24, which is taken on record. Any of the memo, any of the submission from the petitions and dismissed as infructuous, as having become infructuous.
Your Lordship, this is an admission matter.
If I is in education matter, that is not reaching a very, I filed application for clarification of the order, Disham Court Malad granted liberty to challenge the order passed by the Education Department, which was produced during the course of the pending of the hearing Malad. But that portion of the order was not typed in the order Malad, therefore I filed application for modification of the order Malad, because it is an education institution. I've been I'm unable to admit the students to the institution. It may be taken up at the,
Taken up when it reaches, will take up.
my lord, twice it is listed, but it is not reached, my lord. Therefore, my lord,
No, it will reach. Why?
please, my lord,
Yes.
please, my lord.
Lordship, this is an education matter, my lord. This is an last date 4/6/2024 listed and adjourned date 22/7/2024, my lord. I am filed application for posting today, your Lordship. Kindly have it on some
Admission to which course?
Your Lordship, this is a medical admission post, my lord. Counseling is started.
So it is a new petition or pending?
Lordship, pending at 2023.
File IA.
IA for posting is filed today, my lord, in the counter.
Get it listed
Tomorrow, my lord.
day after.
Much lord.
Yes.
Your Lordship, these are the pollution control board matters where your Lordship had heard on a special bench on Thursday. These two matters were connected with the review petition, however, it was not listed. Similar orders may be passed, Your Lordship.
Which matter, which bench, which?
Your Lordship, which Honorable Justice Krishna Dixit, Your Lordship.
So you go before Registrar Judicial. You can't make such a request before in the open court. Come to Registrar Judicial. We'll pass appropriate orders on the administrative side. Yes.
I am the petitioner in item number 35 today, my lords. Pray for 2 weeks' time. It may be listed on 29th if it please your lordship.
29th, 35,
29th.
29th you want?
Item number 35, my lord.
29th.
Much obliged, sir.
Serial number 10, my lord. My senior counsel has not recovered from the open heart surgery. Kindly give me 2 weeks of adjournment. Serial number 10.
6th of August.
Much
At the
obliged.
request of learned advocate Mr. Srinivas K.N. on the ground that the senior counsel who will be conducting the appeal is in indisposed health. From a stand over to 6th of August. Yes.
Your Lordships, this is a matter pertaining to
Date of
DPC. Your Lordships, this is a matter pertaining to DPC proceedings. The DPC meeting is scheduled to be held this week. Your Lordship, if it proceeds without the matter being heard, the
Which
writ
meeting?
appeal may become infructuous.
Which meeting?
DPC, Your Lordship, Departmental Promotion Committee meetings.
Motion can-
Your Lordship,
motion-
also there's a contempt petition on the same dispute listed tomorrow, Your Lordship. If the two matters can be heard tomorrow, kindly, Your Lordship.
Promotion can always wait.
No, Your Lordship, it's absorption, not promotion. It's an absorption matter, Your Lordship, not promotion. But the meeting, DPC meeting is scheduled to be held this. Your Lordship, there's a contempt petition on the same dispute listed tomorrow. Kindly, Your Lordship.
No urgency. Yes, yes, madam. Yes.
My lord, writ appeal was dismissed for a non-prosecution, my lord, non-compliance, my lord. I have complied the office objection, my lord, and I have filed the recall application, my lord. The connecting matters are coming on 16th, my lord. Kindly posted on 16th.
16.
My lord, serial number 9 and 32, my lord.
9.
9, serial number 9 and 32. From incoming, kindly have 2 weeks time.
No.
Particular matters are posted on 30th.
Let it be called off.
My lords, fresh matter, my lord.
You be here, there will be dismissed. Unless you are here, it will be dismissed for want of prosecution.
Dinner is held up in Dharwad bench. Dinner is held up in Dharwad.
We'll see if you be here. Is it Dharwad or held up in Dharwad?
Held up in Dharwad.
At Dharwad. At Dharwad. Or through video. He is here or at Dharwad?
Different matters are posted on 30th.
No, we are not granting time. That is final. Yes.
My lords, fresh matter, my lords. Connected matters are coming up on tomorrow, my lords.
Which
It may
one?
be- It's a appointment of an president under National Commission for Homeopathy Act, my lords.
Appointment of
President under National Commission for Homeopathy Act, my lords.
homeopathy.
Please, my lords. Connected matter is coming up on tomorrow, my lords. It may be tagged along. My lords, with respect to the appointment
All
of
right, two
chairman,
more.
with respect to the appointment of chairman, which is reserved before my lordship, my lord.
That is already heard, madam.
Please,
That matter is already heard and awaiting the orders.
please, my-
It is to be posted today, that is right. We'll get it listed tomorrow.
please.
Yes,
Serial number 75, my lords, appeared for the appellant. This is for the complaints for the council submission. We have that respondent number 1 to 4, the statement of objection has not been filed, my lord. And the caveator's copy, I'll be serving, I didn't bother caveator, I'll be serving. I want one short date for the admission.
3 weeks, yes.
My lordship kindly, serial number 38, my lord, on the last week, my lord,
38.
38. When we mentioned it, my lord, expect to mention it at 10:30. Today, the senior advocate is in Delhi. Senior advocate requested at 2:30. 2:30, we will argue the matter in VC, my lord. It's a matter where the Pollution Control Board chairman term is very limited. And after change of this government, though the humble apex court confirmed his appointment and to continue up till 14th of November this year. With malifiers, they have dismissed him and they have discharged him. That's the matter. Only term is only about 2 months. 2:30 it may be taken up.
It
No,
will reach. It
My
will
lord,
reach.
last week, my lord, when it was mentioned about,
At 11th, you can't say that no matter will reach.
no, last week, my lord told me to mention it at 10:30. That's why I'm mentioning. Otherwise, I would not have.
At 11, no priority. Let us see how board proceeds.
I would not have mentioned because my lord expressed it on the last week when the seriousness
But
was.
then, no, sir. Yes,
My lord, serial
no priority in that way.
serial number 47, my lord,
Yes.
relates to the doctrine of pleasure appointment under the Central Relief Committee. Doctrine of pleasure. This, the learned AG will be appearing. Your lordship mentioned that if we mention it in the morning, it could be heard by 2:30 today. Last hearing, my lord, your
It
lordship
is
had.
same
men-
Rajiv Gandhi University.
No, this is different. They were heard together, then they were de-tagged.
We'll take up, let us see.
2:30, my lord, because here,
Let us see what happens at 2:30. At 11, no suppositions, yes.
because
My lord, it's a fresh matter. The appellant is an auction purchaser from BDA, my lord, who has sold the site to the appellant for a sum of 10.5 crores, subsequent to which they have auctioned the same property in an e-auction. Such a bid was not accepted by the auction committee, my lord. So the bidder challenged this before a writ petition before this honorable court. The writ petition was allowed, my lord, and the sale deed was directed to be made within 4 weeks. My lord, the BDA has also filed an appeal to this order, which is before before Court Hall number 2 on 22nd, my lord. The matter may be clubbed together and heard on 22nd. my lord.
We club before court number 2.
My lord, both the matters may kindly be clubbed together.
Go before register judicial. Or when it is taken, we request, we'll see.
My lord, a date may be fixed, my lord, due to the urgency.
Today listed,
My lord, it's a fresh matter, my lord.
where is new?
New, fresh matter, my lord, we have just filed.
Let it be posted, then we'll consider.
My lord, a date may be fixed, my lord. A date may be fixed, my lord, for the fresh matter.
19
Please, my
or
lord.
18, 18.
Please, my lord. Grateful, my lord.
My lord, this is a writ appeal. We are for the respondents. An interim order is operating against us, my lord.
Serial number?
This is, we have to, for the memo for posting, my lord. We have filed a application for vacating the stay, my lord. BDA are troubling us in view of the interim order, my lord. Any day is fine, my lord. Any
18.
18. Obliged.
This is list number 2, seal number 1, Mr. Anil Kumar. This is office objection along with council submission matter.
Office of this, 3 weeks. Learned counsel for this.
May I make one submission? My apologies big, because on office objections, the senior counsel is not supposed to make any submissions. But there is an urgency in the matter. Out of the 46 admissions made by the first petitioner, 26 were approved by the second respondent, Rajiv Gandhi University. 20 are not approved. The examination commences from the next Monday. So some interim judicial intervention may be made for them to appear for the examination. Rest subject to the result of the writ petition.
That you argued, don't argue. Subject, we have not said anything subject to the result of the petition.
Not
You
that-
have removed the office objections?
That's the defect, my lord. I'm not
What are the,
defending
what
that,
are
but-
the, what are the objections? Do it, 11th will post. If the office objections are removed on or before 11th, this petition shall be listed on 11th.
During the published, during.
The contempt matters, list 1, seal number 1. Mr. Mali Anand Kumar.
Your Lordship, kindly have it at 2:30. In this, kindly have it at 2:30, I'll file the affidavit, Your Lordship.
Kindly have it.
2:30, Your Lordship, I'll file the affidavit. On last date of hearing, I have made a mention that we have not changed the revenue entries. So the interim order.
2:30.
Your Lordship had directed them, they're supposed to have given. If he gives at 2:30, then I will reply in the morning, if my
Please.
lord.
He is filing some affidavit.
Yes, I'm filing the affidavit of compliance saying that their grievance is only that violation of the interim order, saying the state, we have not violated the
No, no,
order.
no. I only thought if he gives in advance, we'll take a look at that, so that we assist the court.
I'll have it
time.
served before 2:30. I'll have it served.
Very good. Obliged.
List number 2. So Madhusudan,
For the complaint. The order of the single judge is at page number.
Notice returnable on. August 8th August.
seal number 3. Mr. Hiremat.
For complaint, this matter, Your Lordship.
Notice 8th August.
The petition- complaint is the agriculturist and the owner of the land bearing survey number 73, Your Lordship. Already the same, some persons in the same survey number has filed the writ petition and issued the saga chit to the persons. But after passing the order of this honorable court, even I have filed the several representation, no answer has been given by the accused and also no saga chit has been issued till today, Your Lordship. I filed for the compliance of the order of this honorable court passed in the order WB number 9250 per 2023, Your Lordship. The page number 9, Your Lordship. May I read? Having taken note of the awareness made in the writ papers as the competent committee had taken the decision 3/2/2014 Annexure B, to grant land to the extent of 1 acre 8 guntas in survey number 73 in favor of the petitioner herein, and therefore respondent 3 herein is directed to consider the representation dated 2010-2022 Annexure J in the light of the order passed by the respondent number 2 herein dated 27/11/2017 Annexure J within the period of 4 months from the date of receipt of the order.
So PL matters, seal number 4.
Please.
Mr. Ramatullah Kotwal.
Appearing for the government, my lord.
Appear for the
First is appearing for the petitioner, Your Lordship. Your Lordship, this writ petition PIL filed by the petitioner seeking the mandamus to take action against the respondent number 8 to 17 for creating disharmony within the society and promoting enmity before between the religious, Your Lordship, for hate speech.
What are you doing in life? Please take. What are you doing in life?
I'm a social activist, Your Lordship. But the petitioner is a social activist.
What do you mean by social activist?
Lordship.
You must be engaged some in profession, some business, some
He's
service.
he's a businessman. He's a businessman.
Businessman.
Yes, Your Lordship, and social activist. He'll engage with the social activities.
What kind of business you are doing?
Your Lordship, please.
You are not stated anywhere in the petition, except saying that you are not involved, you are a citizen of this area and that area. What are your credentials as a person? or as a citizen? You engage in what profession, what business, what is your source of earning?
I need to
Don't
take
know
instruction
about your
about the
client.
as business and your lordship.
You don't know about your client.
Your lordship, kindly see the.
Who has
pa-
drafted the petition?
lordship.
Who has drafted?
Para 5 is the.
Why you are misusing the platform of the High Court by filing such petition?
Lordship.
Take your
this-
seat. What do you want? You are against some, you are alleging some hate speeches against some particular community. By
Lordship.
all the respondents, 8 to 17.
Yes, your lordship.
So you disclose what you are in life, how you are connected with these persons. What is the motive for filing this petition?
Lord, I'll take instruction. Kindly fix a date for. I'll take instruction, your lordship.
Why take instructions? Right now you must tell us.
Lordship, the petitioners.
Why you are wasting the time of courts with such petitions?
Your lordship, kindly see the page number 38, the complaint representation given to the respondents departments, your lordship. So far as no action taken against these respondents for
File
hate
individual
speech.
complaints, etc. If there is a defamation or anything. Why such omnibus petitions? That too in a public interest petition.
Lordship, these.
Are the High Court is meant for such petitions?
No, your lordship, please.
So what do you propose? You are inviting order or withdrawing? Right now you decide. We are ready to pass the order,
Your lordship,
what we think fit.
I need to take instruction
No
from my
instructions.
senior. your
Matter is
lordship.
called
He's-
out. No, sir.
He's in,
Will be no
he's
time will be
engaged in
given.
apex court, your lordship. And
No time will be given. If you are unable to answer the query, don't answer. You are not aware what your client is doing in life.
your lordship, kindly pass over the matter, I'll take.
We will not pass over the matter. Why to pass over?
Need to take instruction about.
No
this,
instruction.
Background, your
It is
lordship.
now called out and answer whatever queries are there. Or invite orders. If you don't know about the credentials of a client, minimum where he is in profession, what is he doing, then what is the use of your appearing? That too such a frivolous petitions, public interest petition?
Yes, your lordship. I apologize.
Now
Your
tell us.
lordship, kindly fix a date for, in next week, your lordship. I'll
No,
take instruction and I'll
no,
make submission
no.
about the petitioner, your lordship.
No. Third learned advocate, Mr. What is a good name?
Anwar.
This is serial number 4. Mr. Anwar,
Muhammad Anwar. Muhammad Anwar.
Muhammad Anwar. Third learned advocate, Mr. Muhammad Anwar appearing for Rahmatullah Potwal and Potwal
Your lordship,
Company.
your lordship on submission. He's a civil contractor, your lordship. Civil contractor.
Very good. Civil contractor files such an uncivil petition.
Your lordship, he is engaged in social activities also, your lordship. In
We are not concerned with all this. You file the defamation complaint, whatever you want to file. What
He
kind
ha-
of petition you are
has
filing?
filed complaint
No,
before the police station and with the commissioner also.
Go
But
there.
since no action taken against these
You can't
respondents,
invoke such a matter for public interest. It's total misuse of the court process.
there is a guidelines.
Are you withdrawing
from-
the last question, last chance? Or we invite the order?
I'll take instruction, your lordship. Kindly adjourn that for 2 days, your lordship.
Right now,
My senior is he is engaged in apex court, your lordship. for-
right now, no time.
So I need to, then your lordship may kindly pass over the matter for 2:30.
Will not pass
I'll take
over.
instruction and I'll come
No,
make submission. your
No. Having spent the time, having heard, having considered, having read the matter, we are not going to pass it.
lordship. The petition filed, your lordship, the Supreme Court guidelines to take preventive measure on hate speeches, your lordship. Kindly see the page number 53, the judgment I have annexed, your lordship.
Yes.
Tahsin Poonawalla versus Union of India. Your lordship may kindly see the page number, the relevant portion,
Page
and
number?
page number 77, your lordship. para 40,
77.
77, the relevant para of judgment, Your Lordship. Para 17, in view of the aforesaid, we proceed to issue the following guidelines. Preventive measures. The state government shall designate a senior police officer not below the rank of superintendent of police as nodal officer in each district. Such nodal officer shall be assisted by one of the DSP rank officer in the district for taking measures to prevent incident of mob violence and lynching. They shall constitute a special task force so as to procure intelligence report about the people who are likely commit to such crimes, who are involved in the spreading hate speeches, provocative statements, and fake news. The state government shall forthwith identify district subdivisions and or village where instances of lynching and mobile violence have been reported in the recent past, say in the last 5 years. The process of identification should be done within the period of 3 weeks from the date of this judgment, as such time period is sufficient to get the task done in the today's fast world of data collection. The Secretary, Home Department of concerned states shall issue directive advisors to the nodal officers of the concerned district for ensuring that the officer in charge of the police station of the identified areas are extra cautious if any instance of mob violence within their jurisdiction comes to their notice. Worship, may kindly.
We are hearing you very patiently.
The nodal officer so designated shall hold regular meetings at least once a month with the local intelligence units in the district along with all station house officers of the district so as to identify the existence of the tendencies of vigilance, mob violence or lynching in the district and take steps to prohibit instances of dissemination of the offensive material through different social media platform or any other means of insting the tendencies. The nodal officers shall also make efforts to eradicate hostile environment against the any community or caste which is targeted in such incidents. The Director General of Police, the Secretary, Home Department of the concerned states shall take regular review meetings at least once a quarter with all nodal officers and state police intelligence heads. The nodal officer shall bring to the notice of the DGP any inter-district coordination issue for devising a strategy to tackle lynching and mob violence related to issue at the state level. It shall be duty of every police officer to cause a mob despair by exercising his power under section 129 of CRPC, which in his opinion has tendency to cause violence or break the havoc lynching in the disguise of vigilance and otherwise. The Home Department of the Government of India must take initiative and work in coordination with the state governments for sensitizing the law enforcement agencies and by involving all the stakeholders to identify the measures for prevention of mob violence and lynching against any caste or community and implement the constitutional goal of social justice and rule of law. The Director General of Police shall issue a circle to the Superintendent of Police with regard to police patrolling in the sensitive areas, keeping in view incidents of past, the intelligence obtaining by the Office of Director General. It singularly means that there should be a seriousness in patrolling so that antisocial elements involved in such crimes are discouraged and remain within the boundaries of law, thus fearing to even think of taking the law into their own hands. The central and state governments should broadcast on radio and television and other media platform, including the official website of the Home Department and Police of States, that lynching and mob violence of any kind shall invite serious consequences under the law. It shall be the duty of the central government as well as the state governments to take steps to curb and stop dissemination of irresponsible and explosive messages videos and other materials on various social media platforms which have a tendency into incite violence and lynching of any kind. The, the police shall cause to register FIR under section 153A IPC and other relevant provision of law against persons who disseminate the irresponsible and explosive messages and videos having content which likely incite mob violence and lynching of any kind. The central government shall also issue appropriate direction advisories to the state governments which would reflect the gravity and seriousness of the situation and the measures to be taken.
That's all, without disclosing the avocation or profession in which the petitioner is engaged, comma, the present public interest petition is filed, wherein the petitioner claims to be a public spirited person, to further claim that without personal gain, private motive, or without any oblique reason, the instant petition in the nature of public interest litigation is presented before the court. The prayer in the petition is to take preventive, remedial, and punitive measures against private respondents, number 8 to 17, in respect of their alleged speeches. Petitioner claims that he came across certain speeches from media reports, internet, and such other mediums to know that private respondents number 7 to 18 are engaged in speeches which could be characterized as hate speeches, and that the speeches are actuated to malign a particular community. Paragraph. When in course of the hearing, the query was put to the counsel for the petitioner as to in what profession he is engaged, comma, the counsel, learned advocate with much difficulty would answer that the petitioner is a civil engineer. Be as it may. The several prayers attend to the same aspect, that the private respondents have delivered certain speeches which are not in the interest of particular community. Full stop. It is the case of the petitioner that the Supreme Court, Honorable Supreme Court, has laid down guidelines in respect of hate speeches in Tehseen S. Poonawalla versus Union of India, which was writ petition into bracket civil number 754 of 16, decided on 17th July 2018. And that the facts of the present case require that the said guidelines should be implemented against the private respondents. On carefully going through the petition, comma, the petition is too general to be countenanced. The allegations lack authentication. Even otherwise, comma, petition of such nature cannot be entertained as public interest litigation. Full stop. The filing of the petition smacks motive other than public interest. the petitions filed in the nature of public interest litigation with political or communal motive cannot be entertained. No case is made out to entertain the present petition. It is liable to be dismissed with cost. However, taking lenient view, it is summarily dismissed.
So number 5, the Rudra Papi.
Petitioner in this case. My lord, the petitioner is seeking direction against respondents, my lord, to fill up the vacancies in the consumer commissions, my lord. State commission and district commissions, my lord, across the state, my lord. As per the order,
So since how long the vacancies are not filled up?
my lord, time and again, not they have, time to time, they were, some of the members and presidents are retired, my lord.
Which?
President of the state commission, my lord, has been retired on 17th May, my lord.
If you are vague, we will not entertain.
We have produced the
Which are
list, my
the-
lord.
Which are the vacancies not filled up?
Annexure A may kindly see, my lord.
Let us. Yes.
With particular dates we have mentioned, my lord, annexure A.
The grievance in this public interest petition is in relation to the non-filling of
The interim order has been passed, my lord, by
vacancies
the,
of presidents and members of the state commission and this state consumer commission and state consumer disputes redressal commission and the district consumer commissions. Full stop. The list of the vacancies which are not filled in, figures on record into bracket page 19 annexure A. It could be seen that certain vacancies are vacant, certain posts are not filled in and have been vacant since 2022 as well. Notice to the respondents, returnable on.
my lord, interim order may kindly be, my lord.
What?
As per the order of the Honorable High Court of Uttar Pradesh, my lord.
No interim order.
The interim prayer order has been granted with the similar, very similar matter, my lord. Honorable Supreme Court also issued some observation on this, my lord. Issue is pending
Then
before the
you are
Honorable
supposed
Supreme
to
Court.
take
my lord.
some examination.
My lord, I will seek instruction.
That is
To
the.
continue the present members, my lord. Only that interim relief, my lord. We are
Anyway,
seeking.
no interim, 5th of August.
Annexure B may kindly see, my lord. Annexure B may kindly see.
That day you.
Lord, I take.
The similar order has been passed with the Honorable High Court of Uttar Pradesh, my lord. Annexure B, I
What
produced
is
it before.
what is the interim order? Who has passed? Supreme Court has passed.
Supreme Court also confirmed the order, my lord. Your lordship may kindly see me. Case number, the party's name which is mentioned in the annexure B, my lord, is very same parties, my lord, the Ganesh Kumar, Rajeshwar Rao, Selukar and others. The very same order has been placed before the some court of page number 17 or 27, my lord.
There is no interim leave, as we are claiming.
Page number 27, it is there, my lord. Kindly,
Can't be granted even if it is.
not in that order, my
We'll
lord.
consider after they appear.
It is a part of the writ petition, not annexure, annexure B, page number 27, may kindly see.
Which one?
Annexure B, my lord.
In this, there is no interim leave.
My lord, interim order in this annexure B, my lord. Annexure B may kindly see, page number 27.
We are not granting interim. 5th of August.
Right.
So green bench matter, seal number 6, Mr. P. Vittal Chetty.
Serial number.
My lords, I appear for petitioner, my lord. The sixth respondent had purchased agriculture land on 21/11/2019 to the extent of 99 cents in survey number 213/1 of Idu village, Karkala Taluk. Subsequently, on 31/7/2000, the respondent had sought for NOC from the respondent 1 for conversion of the 99 cents of land in survey number 213.
Issue notice.
Yes, your lordship.
Notice returnable on
The interim,
6th August.
interim order may be,
No, there can't be interim order. It will amount to allowing the petition. Learned advocate Miss
Rishika Vaishnav for A. Mahesh Chaudhary.
Vishnu
Yes, sir.
for so and so, so and so. Accepts notice on behalf of the pollution control. 6th August,
notice.
6th August.
Still number 7. Mr. Shura generally.
Appear for the petitioner in this environmental compensation orders.
So that is governed by that
Please, my lords.
same order.
Yes, my lords.
So wait for some,
But then, my lords, my
same which was dealt with.
Yes, Your Lordship, the matters. which
council's
have
one
been disposed
submission.
of.
In this petition, my lords, we have sought for a declaration that, my lords, the action is illegal with being covered by that Honorable Justice Oak's judgment of this honorable court. My lords. My lords.
Will dispose. It includes everything.
My lords, once, in this case, my lords, very same parties, Honorable Justice Oak on 17th day of March 2020.
Even if you submit for an hour, we will not be able to take different. view.
Yes.
Declaration you are seeking will include everything when it goes back. To submit everything before then.
My lords, this is second round, my lords. Again, if they pass an order, then, my lords, I'll have to approach this honorable court.
Then let us see notice returnable on 6th of August. Ms. Vaishnav accepts notice on behalf of pollution control.
Stay may kindly be given.
No stay,
My
nothing.
lords,
We are ready to dispose on the lines of the group, but you are
please,
not
my lords,
willing.
please, my lords, as your lordship pleases. Because it's going to go before the very same board and the, my lords, I assume that, my lords, they'll look into all those things and pass appropriate orders.
So do one thing, wait for that order. We'll keep it on 18th. You see that order and then satisfy yourself. The order which you are going to pass in that group. Once it is out, you go through that order, satisfy yourself, and then we'll dispose of this petition.
Until then, this order will be hanging on me, my lords. The petitioners.
Why hanging?
The petitioners
No,
are very.
they are not going to take any action.
If
In
they
that
sub-
group also, they made a statement.
Yes.
So
In
wait
these
for
two,
18th.
and this coupled with one more petition, same points, my lords, 36.
Whenever it comes, we'll deal.
My lords, 36 also same, my lords.
So simply 18th of July.
However, your lordships.
What is wrong in it? We are only contrary saying that you go through that order when it is comes and then
Until then, let them know precipitate.
if it is acceptable, then yes, not acceptable, then argue. 18th.
If the board had brought those orders, my lords, to the knowledge of this honorable court, then these things would have not cropped up, my lords.
Finally, what do you want?
We want to stay and
Stay will not be granted.
quashing, my lords, quashing of the time.
Same order,
Same one.
same order.
Annexure is the same kind of order. my lords.
Same order which are going to pass. Namely that this will be treated as so cause notice. It will go back. The order will be set aside only on the ground that you will be given opportunity of hearing and entitled to raise all contents. Which you argue and disposed of.
But it's the very same point, my lords, with the same party, it's already done by this honorable court
So
in.
then come on 18th. We are not prepared to 18th.
Please, my lords, as your lordship pleases, my lords. This time as well as 36, my lords, I'll go before them and I'll come back again.
18, now 18 days. Let us see.
Please. 36 also, my lords. 36 also, same. point.
36 also,
Same point, my lords.
same. point.
Let them not precipitate, my lords, where they're all very small,
They will not precipitate.
much of.
Great.
Still number 8. Still Chidanand.
Petitioner minute. That the application filed by the petitioner is rejected. Basically on two grounds, my lord, that the fourth respondent belongs to scheduled caste community. He is entitled a preferential right under Rule 12(1)(a). My lord, the second ground is, my lord, that the petitioner has quarry lease of 50.19 acres, my lord. my lord, this 12(1)(a) was inserted by the amendment, my lord, 2013, my lord.
So what is the ground for rejection, Mr.? You are appeal?
Yes.
What is the overlapping?
The total area, not the petitioner acquired is more than 50 acres. Under Rule 15(1).
My lord, your lordship may kindly see, my lord, this order is bad for 3 reasons, my lord. One, the second respondent is not the competent authority either for grant or rejection, my lord. Under Rule 11(4), it is a state government, my lord.
Appealable or
It's not, my lord, it's
Revision-
state government.
revisable.
revisable?
My lord, of course, the revision is there under 50 through, just it is on the, without giving a notice and opportunity to me, this application is rejected, my lord. In fact, I have extracted, my lord, at page 3, I have only 19.9 acres of the quarry lease, my lord. Now he comes to the conclusion, my lord, without giving any notice and opportunity to me, saying I have a 50 acres of quarry lease. I have applied, some of them are rejected, some of the applications are pending. My lord, the maximum area is applicable when I have more than 50 acres. As on today, I have given, my lord, the quarry leases. I have about 19 acres of quarry lease. I am entitled maximum of 50 acres because I am 100% export oriented in it. And this he passes an order, my lord, without giving any notice to me, my lord. He has not given me any notice, my lord.
May make.
My lord, his application of rule.
An application for quarry lease. The question of affording opportunity does not arise. And the authorities have noted down clearly, your lordship may kindly see in.
That you show that it is demonstrable that the area exceeds 500.
Yes, Lord,
No,
they
no,
have
this-
clearly mentioned in the order itself.
Para 3 of my writ petition, your lordship may kindly see, my lord. My lord, he gives notice to all
Page
the persons
33 and
except to
34.
me, my lord.
Page
33 and 34.
33.
The details of quarry leases granted in favor of the petitioner has been tabulated. And ultimately, my lord, in page number 35,
So table at page 33 is what? Already existing?
Yes.
Existing. And table at 34, second table
Yes.
is what?
That is in the name of
Same.
Medani,
Other-
yes.
Yes.
Medani. He has quarry leases in three names. One is Ganapati Granite Impacts, then Messrs. Medani and Vinayaka Rocks.
My lord, even according to his own statement, my lord, is less than 19 acres.
It exceeds 500 acres?
No, my lord, it is 19 acres. Your
50
lordship may kindly see, my lord.
50.19 acre.
Total area of
That is in respect of major mineral.
50 acres. B.
B is applicable.
My lord, may I just draw my lord's attention, my lord, in page 33, my lord.
Where is that finding?
My lord, no, your lordship may kindly see, my lord, he's
Page number 35.
35.
Para, last, second para. As stated above.
So all, total 38 acres and 27 hotels. Existing.
No, not. He's, as stated above, already granted quarry leases and seeking no objection for grant of quarry leases. The total extent is 50 acres, 19 guntas, exceeds the limits of the area 50 acres under Rule 15.1 and 15.3 of KMCR 1994. Therefore, pass the following law.
like just 33 may I draw, my lord, according to his own statement, my lord. 33 for a minute, my lord, order, my lord. What I have is, my lord, 3 quarry leases, my lord.
So existing doesn't increase 50. Existing leases of the petitioner, area doesn't increase 50 acres.
It is 19 acre receivable, according to his own statement, my lord, para 1 to 3, my lord. One is 10 acre,
It is
2
19
acre,
acres and
20 guntas,
19 acres and 25 guntas.
20 guntas. My lord, secondly, his interpretation of Rule 12A, my lord, and he says, my lord, the fourth respondent is entitled the preferential right, my lord. So
No.
12A, my lord, the only when there are more than one areas, my lord, the lease can be granted to scheduled caste and scheduled tribe, my lord. Rule 12A prescribes, my lord, 15% and 3%, my lord. It doesn't exclusively give a right to the scheduled caste person to claim in respect of a property which is a single area, my lord.
And the fresh one is for 4 acres and 32 guntas. So that can be granted. You demonstrate that the total exceeds.
Flood, in translation, it is not actually worded. May I read the Kannada version and then translate. In page number 30, the last para, Messrs. Ganapati Impacts Private Limited, Company Esrinalli Tumkuru, so and so. What to the total extent of lease granted in the name of Ganapati Granite is 19 acres, 35 guntas. And in the name of Messrs. Vinayaka Rocks Private Limited, Chikkaballapura,
So the
so and so.
director is common. Director is common.
Director is common.
So sub-rule 3 will apply.
Yes. And 38 acres, 27 guntas in respect of.
Even then 50 thash.
I'll come to that. 38 acres, 27 guntas in respect of Ganapati Impacts as well as Vinayaka Rocks. Then coming to the next paramla, under 8B. 8B.
What is 8B?
8B is fresh grant. Fresh grant.
Yes.
They have filed an application for grant, and in which we have sought for no objection from various authorities. That is in respect of 11 acre 32 guntas. This is a fresh application again. The total extent exceeds 50 acres, what has been prescribed under the rules.
So by virtue of new application, it exceeds.
Yes.
These Dhanika grenades are their own company?
No.
They're also directors are same. Dhanika grenades.
No, measures.
Dhanika. In the second table at page.
Yes, yes, Dhanika is there.
They also their own.
Their own.
Milord, they are not common directors, Milord. The company is totally different, but some of the directors of this company are also there, Milord.
It will fall within sub rule 3.
Sub-rule 3, your lordship may kindly see, Milord. Now, Milord, I have two grounds, Milord. One, the director of mines and geology is not the competent authority, Milord. He has to take the records and forward it to the state government. It is a state government which is the competent authority under Rule 11(4), Milord. He is not the competent authority to decide, Milord. He gives a notice, your lordship will kindly to all others, Milord. He doesn't give a notice to me. Milord, if he has given a notice to me, I would have placed, Milord. I do not have a quarry lease of 50 acres, what he is trying to claim, Milord. And he includes the applications which have been filed, Milord. It is without jurisdiction for the reason, Milord. He is not the competent authority to decide under Rule 11(4) is a state government in case of specified minor mineral. And he rejects the application, grants the quarry lease to the fourth respondent.
Not if the petitioner is aggrieved by the calculation made in the impugned order, then revision is available. Can agitate the same before the revisional authorities also.
You are a scheduled caste.
Milord, if it's a single area, Milord, of course, under the Service Milord Act in Chakradhar Paswar and series of judgments said, if it is a single area, Milord, it amounts to 100% reservation. Milord. Can this be decided by the government is the issue, Milord.
What is this notification 16, 12, 13?
That is the one which inserted Rule 12(1)(a), Milord, which provided for, Milord, reservation in the matter of grant of quarry lease to scheduled caste, scheduled tribe, Milord. 15% and 3%. In an area where there is a single application of 7 acres, is it legally permissible to grant a quarry lease? Milord, even as per the calculation given, Milord, it is 37 acres, Milord.
So number 4 is also applied.
Number?
This one number 4 has also applied.
He applied for the same area, same day, my lord. Now, my lord, by virtue of the order of the Supreme Court, my lord, under Rule 8BE, my lord, Rule 12 will be applicable, my lord, priorities. My lord, the petitioner is 100% export oriented unit, my lord, is carrying on, my lord, cutting and polishing of the slabs into monuments and exporting outside, my lord. Therefore, the petitioner has a preferential right at 12(2), my lord. Page 30 minutes.
File notice written.
Lord, so far as preferential right and defects in.
That pales into insignificance once it exceeds 50 acres.
But even according to
And-
37 acres, I am having lease of all the companies which I own. Even according to his calculation, Millard, at page 30, it is 37.37 acres. Millard.
Then you are asking for how many?
But I am another 7 acres. Millard. I have a maximum, I can take 50 acres. Millard.
That he can file a revision, Lord. Revision is available to him.
Like interpretation of
For
Rule
the-
12(1)(a), Millard, the authority under.
No, no,
Rule
it is not in
53
the
may not be able to
interpretation.
decide that matter, Millard, because the authority says once an application is filed by SC/ST, all other applications cannot be considered. That is the substance of the order.
Rule 53.
53(3).
How do you say that 37 plus 7?
A calculation, your lordship, may kindly see is that page, in fact, he has given, Millard. Ganapati granite, there are 2, Millard, 10 acre, 2 acre, 20 gunta, 7 acres. According to Millard, this Vinayak Rocks Private Limited, Millard, 7 acre, 20 guntas, 3 acre, 12 guntas, 8 guntas. It's 37 acres. Millard. Even according to his calculation, Millard, he takes into consideration the applications filed by me, which are, some of them are rejected, some of them are still under consideration.
Hard learned educated go in the.
May,
hard
may,
learned-
may, once, if there is a calculation error, 54, Rule 54 comes into picture. If there is a mistake, he can bring it to the notice of the competent authority. Clerical error, may I read, Lord, 54? Power to rectify apparent mistakes. Rule 54. Any clerical or arithmetical mistakes in
50?
4,
55.
55, I'm sorry. Any clerical or arithmetical mistakes in any order passed by the competent authority, director or the state government, or any other authority or officer under these rules, and any error arising therein from the accidental slip or omission may, within 1 year from the date of the order, be corrected by such authority or officer as the case may be.
Hard learned educated so and so the petitioner. And learned government advocate Mrs. Mahendra for the respondent upon service of copy of the petition in advance. Paragraph. The controversy in this petition filed under Article 226 of the Constitution, surrounds order dated 3/2/24 passed by the.
Second respondent.
Any interruption will not be told.
I'm sorry.
Please sit down.
Yes.
Passed by. Respond number 2, that's the Director, Department of Mines and Geology, whereby the application of the petitioner for grant of co-release, which was application number 319 of 14 dated 21/1/14, came to be rejected. The petitioner Messrs. Ganapati Granites Impex Private Limited had applied for grant of multicolor granite quarrying operations in the government land bearing survey number 78 at measuring 7 acres and 10 guntas, situated at Taware Kere village, Unigal Taluka, district Tumkur, under Rule 12(1) small Roman 2 of the Karnataka Minor Mineral Concession into bracket Amendment Rules 2016. The sole ground of rejection of the petitioner's application is that the total area of leases held by the petitioner exceeds 50 acres. The details of the quarry leases held by the petitioner are given in the order in tabular form to arrive at a conclusion that the area exceeds 50 acres. Paragraph. It was submitted by learned government bidder that once the area, total area for quarrying leases, for total area of one or more quarrying leases exceeds 50 acres, comma, the bar of Rule 15 of the rules operates, which says that no person shall acquire in respect of any minor mineral in the state one or more quarrying leases covering total area, which inter alia provides them, covering a total area of more than 50 acres for the purpose of mineral-based industries and 10 acres in case of other purposes. Full stop. Invited, the attention of the court was also invited, subsections to sub-rule 3 of Rule 15, which says that for determining the total area referred to in sub-rule 1, the area of land held by a member or partner of a company who is common in two companies would also be taken into consideration. Be as it may, paragraph. When on the other hand, learned advocate asserts that the total area does not exceed 50 acres for the quarry leases the petitioner has been holding either in the name of Messrs. Ganpati Granite Impacts Limited or in the other names where the directors of like partners are common. Paragraph. The dispute as to whether the petitioner has more than 50 acres of land or not for one or more quarry travels in the factual realm. Full stop. It was pointed out that remedy of revision. It was undisputedly pointed out that the remedy of revision under Rule 53 of the 1994 rules is available to the petitioner. Full stop. The nature of the dispute is such that the revision of remedy is a fit remedy where the petitioner could agitate his case and a decision could be arrived at. Full stop. It is open to the petitioner to invoke the revision remedy. Furthermore, if in the perception of the petitioner, the mistake is arithmetical in calculation of the total area as to whether it exceeds 50 acres or not, Rule 55 would come to rescue of the petitioner, which deals with the power to rectify apparent mistakes, to provide that any clerical or arithmetic mistakes in any order passed by competent authority, director or the state government, or any other authority. May be corrected within the time mentioned in the rule for their accidental slip or omission. Full stop. In no case, the petitioner may apply to the competent authority under the said rule as well. So leaving for the petitioner, either of the two remedies open, the petition is not entertained only on the aforesaid ground without expressing any opinion on the merits of the case.
Liberty is reserved, other sometimes they will.
Liberty is always there.
Let the
It goes without
authorities
saying
will
that-
take a different.
It goes without saying that the fresh development or order pass will give new cause of action for the petition.
Please.
Number 9, Teswa Ishwali.
Nine, yes, what is it?
This kind permission. The similar matters are not adjourned to 30th of this month. I request this matter may kindly take on 30th.
Pardon?
Similar matters are not posted on 30th of this month.
What is
Therefore,
similar here?
The difficulty is not my.
So only a notice to conduct the survey.
That is covered by the judgment of this. Para 10 and 11 may kind.
I will go through this note, kindly have it tomorrow.
Tomorrow at 11.
Pardon?
Tomorrow at 11. There is nothing irrespective of any order. Only notice asking you to remain present in survey. That's right.
That's it.
No, no.
To conduct drone survey.
And they want to conduct DGPS and drone survey.
Infectious. Your dates have expired. That is what my brother is
Ah.
noting.
So far date is concerned, on that date, they are not conducted, I'm told, because due to heavy rain and all that, they did not conduct.
So we need to issue the directions issued by the bench. Some directions are issued. ABC.
There is nothing wrong in conducting drone survey. They cannot object for conducting it.
No, no, no.
Rule itself contemplates for drone survey.
Court order. The rule itself contemplates that conducting DGPS and drone survey, that I'm not disputing, I'm not coming in the way of conducting. The thing is that they want to conduct a drone survey for assessing the quantity of minor mineral which has been extracted from the entire area.
That is the class.
So kindly permit me to read Rule 40, Lord. Under the rule, this rule has been brought, Lord, on 17th of March 2023, prospectively. Kindly permit me to read. Of course, Lord, they are entitled to conduct a drone survey. I will not object for their action and
This specific question was answered in para 10 and 11. May I read?
The challenge in this petition.
not before, just para number, rule number 40, sub rule.
Challenge in this survey, they can't come to your house, place and survey.
What I'm bringing to Lordship's notice is this, that proviso that I wanted to bring to notice. I will not trouble words.
Proviso to?
Proviso of rule 40.
40.
Rule 40 provided that, not.
Proviso to rule 40. Which proviso?
Not.
Only one proviso. Further that no
That
such
is-
annual audit reports will be finalized on the basis same?
provided that the DGPS and drone or total station survey shall be conducted and freeze the reference or reduce the levels of the concession area prospectively through the Karnataka State Remote Sensing Applications Center so-and-so or the empaneled agency by the Karnataka so-and-so agency for the purpose of systematic and scientific assessment of quantity of minor mineral extracted and dispatched from the concession area. Not this proviso brought not into this rule on 17th of March 2023.
17th March 20.
17th March 2023. Now, Lord, under the notice, they want to conduct the entire the quarry area for reassessing the quantity which I've extracted. Not I was granted license. This is my Patta land. I was granted license in the year 2020 on 24/9/2020, that as per Annexure B.
What is
24/1/2020.
24/9?
24/1/2020.
Suche, what is the date of license? What is that date?
Please, 24/1/2020, on which date I was granted license for extracting minor mineral, that is ordinary building stone. From that date onwards, I've been carrying on this business and submitting the audit reports. According to the audit reports, there is nothing from my side. Even according to the audit reports, these audit reports are prepared by the department itself.
So you
That's a
can,
competent authority.
you can convey all these things to them. They will take into account.
Well,
But
of
they
course,
can't be prevented from carrying out the survey.
my apprehension is they want to reassess once again the entire quarry area, and they will reassess and they will recalculate,
We'll
and
say
they want to
survey-
create a
We can
huge
say
liability.
survey report will be subject to their suggestions and objections.
Yes,
You will
they
invite
can
them.
raise objection afterwards also. Now, as of today, there is no
Report.
report.
There is no facts.
There can't be any grievance against the proposed report.
So what is the grievance?
My only grievance is, under the notice, what they've stated is, we want to conduct a drone survey in respect of the entire quarry area. During a drone survey, they will reassess and re-quantify the quantity which has already been extracted and for which I already paid royalty. And according to the audit reports, it is clear that nothing is due from my side. The quantity which is already calculated, imposed, for that they want to, once again, they want.
Such a petition are not advisable at this stage.
Undisclosed quantity
Keeping open liberty.
extracted will be brought out in the drone survey. That is his grievances.
What is sought to be called in question, right? What is sought to be called in question? In
The
this
report is
petition?
adverse to the interest of the petition with such liberty. In the event the report prepared, if the report,
It is all premature, all apprehensive. What is called in question? What is sought to be called in question? In this petition filed under Article 226 of the Constitution is the notice dated 31/5/24 issued by respondent number 3. Who is number 3? Please take your seat. The senior geologist, Department of Mines and Geology, Dharwad. As was rightly pointed out by learned government advocate, Mr. Mahendra, that the said communication dated 31st May 24 is only in the nature of notice whereby it is proposed to undertake a survey of the core release area of the petitioner by remote full stop. It is stated in the notice that the on 26/6/24, the geologist of this office, junior engineer and Messrs. Karnataka State Remote Sensing Application would go to the site of the petitioner, which is core release number 948, for conducting drone public DGPS assessment survey. Petitioner is informed by notice to remain present at the co-release area along with necessary documents and to extend the cooperation. Full stop. It is unfathomable as to what cause of action is available to the petitioner to challenge such a notice by filing a writ petition. Full stop. In the course of the hearing, from a learned counsel for the petitioner expressed apprehension that in guise of survey, they undertake the assessment of entire quarry lease area and and prepare a report detecting the unearthed minerals. Full stop. The authorities have right to undertake such inspection and gather the details of the mining operations of the petitioner. Full stop. The grievance in this regard is misplaced. The apprehension is misconceived. Full stop. No data is collected at this stage. No report is prepared. Only inspection is to be carried out. Full stop. The petition is liable to be dismissed with cost of ₹5,000 to be paid to the Gujarat High Court Legal Aid Services Committee. We'll stop such petitions at notice stage for no good reason.
Then agent seal number 11, the Sharat Goda GB.
Within 15 days, post unpaid.
There is a delay of
Karnataka High Court. Yes.
and there is a delay of 400 and odd days. my lord. There is a delay of 400 and odd days. Delay, yes, my lord. Lord, the learned single judge, my lord, would quash the acquisition notice that was notification that was issued by the appellants. Lord, several of the grounds that was urged by the appellant was not considered by the learned single judge. Lord, please.
How many delay? 7? It's too much delay. 467.
467 days.
Notice returnable on 8th July, 8th August.
Lord.
My lord, I take notice for respondents.
2 to 4, my lord.
Learned edition government. Nilofar Akbar, access notice for 2 to 4.
Seal number 12, the Srikanth.
Please, Your Lord.
Yes.
Petitioners.
Appearing for the respondent.
Petitioners writ appeal matter arises under the provisions of the Maintenance and Welfare of the Parents and Senior Citizens Act. The brief, I have prepared my notes also. Can I share that with the court, please, if the court permits? The appellant Lokesh and respondent number 2 Ayyappa are sons of one late P. Krishna Minister. On 27/2/2019, Krishna had executed a gift deed in favor of his elder son Ayyappa. On 5/3/21, P. Krishnappa executed a rental agreement. That's not relevant minutes at this stage. Then P. Krishna lodged a complaint with the first respondent, complaining that his son Ayyappa has fraudulently obtained gift deed from him and accordingly sought its annulment. After getting a report on the health condition of Krishna, the authority proceeded to pass an order on 27/2/23, cancelling the gift deed, and the same is reflected in the e-signal. Then Krishnappa thereafter bequeathed the property in favor of his second son, the appellant hearing, and got the will duly registered. Krishnappa expired on 14/7/23. Then in the meantime, prior to the death of his father, the second respondent filed an appeal before the DC Miller under section 16 Miller. After bringing the LRs of Krishna on record, DC posted the case for orders. Then the DC order went against me. Now the learned single judge says the order of the AC is set aside, but
both the parties are at liberty to proceed to the civil court. Ma'am. The matter is, scope of section 16 and 23 of the act becomes relevant. So far as 16 is concerned, whether an appeal by a person who is not a senior citizen is maintainable is the question.
Look, your son,
I'm the son, Minister.
son.
Son, second son.
So appeal is filed by you,
My brother,
your brother.
my brother. The gift deed was executed in favor of the brother. Then my father complained to the authority saying that it is fraudulently got executed. Then the authority annulled that gift deed. Then against that order, my brother filed an appeal under section 16. That is not maintainable. That's my submission. An appeal. In fact, my lord's judgment is also there, sitting in Gujarat minutes.
So this Governor Single is order arises from order in appeal under 16.
Learned Single Judge says, since both the persons cannot maintain the appeal, and since the father is dead, you go before the trial court.
So dated 24/1/24 is the order in appeal
Yes, please.
under section 16 filed by the brother.
Filed by my brother.
24/1/24. So this appeal was in respect of cancellation of
Gift deed.
gift deed by your
Yes,
brother,
by my father.
by your father.
So scope of section 16, the earliest judgment is of the Madras High Court. And then by Gujarat High Court, in fact, authored by my lord, the Honorable Chief Justice here.
So this aspect was dealt with by Learned Single.
Yes, it was canvassed.
What he say?
No, he has not gone into that issue. He has said that since my father is dead, both of you are at liberty to go back. If he had only set aside the order of the DC Miller, I would not have traveled. But
Learned Senior Counsel.
My lord, paragraph 5 of the order of the learned single judge may be seen, my lord, page 24. Paragraph 6 also.
So what is the grievance?
the grievance is,
Grieved by this order.
yes, ma'am. My father had executed the gift deed and got it annulled.
The Learned Single Judge, either of you can go to the competent.
True, Miller, but now the gift deed is virtually restored, Miller. That should not have been done. If my lord, the Learned Single Judge had only set aside the order of the DC Miller, fine. But now the Learned Single Judge has also set aside the order of the AC. As a result, the gift deed gets restored. That's my grievance. So the appeal which was not maintainable under section 16 is
Where is that part?
Sorry?
Gift deed is revived.
Gift deed we have produced, means. Gift deed is page 60, Miller.
No. Where is the part of the order which observes or directs revival of gift deed. It only says that either of the, set aside both the orders of the Assist Commission.
Yes, ma'am, that's what, I am agreed by the, setting aside the order of the AC, which my father had got it set aside.
My lord, after the order of the.
So this gift is set under section 23.
Section 16 and 23. Section 16, he could not have maintained an appeal itself.
Said. But about scope of section 23, there is a decision
Yes, ma'am.
of this bench.
This
Have you
bench-
gone through?
I'm sorry, ma'am. This bench,
Have you gone through?
no, ma'am, sir, I went through the judgment of the Honorable Supreme Court, which says,
Will clarify that this setting aside will not preclude you from contending the validity of the, you go through this judgment and come.
yes, I'll go through, I'll go through.
So we'll take care of her grievance by referring to that judgment.
But possession melody is with me now. That possession is with me now. Because EC, everything has been reflected. That's what we have said. After my father got the gift deed restored, annulled, he has executed a will. Pursuant to the will, I got the property also. He's,
Will is executed on 19th April 2023, my lord. Deed has been cancelled on 27/2/2023.
so, therefore, my lord, if the TC order is set aside, I have no grievance. But AC order is set aside, that is the proceedings initiated by my father.
But the Lawrence Singh also grants status quo for three weeks to enable the parties to approach the competent court.
But the gift deed, Miller, is restored. That's what I am, my grievance. He could not have, Leonard Single Judge could not have restored the gift deed in an appeal which is not maintainable.
Yeah, that during the pendency or till you approach the competent court, either of you, the gift deed will remain suspended. Will not operate. And then you pray interim relief before the court also.
No, if the AC order is restored, then Miller, it's for my brother to challenge it, the gift deed. That can be done.
No,
But now, Miller, gift deed is restored.
the civil court can certainly override this order of the competent authority about the validity of gift deed or not.
No, sir, the gift deed is validly executed by my father.
Commissioner, who has passed, who has accepted the validity of gift deed? Commissioner.
Yes, my lord, Assistant Commissioner.
Assistant Commissioner.
Like the gift deed. My lord, thereafter, after the gift deed is set aside, father executes a will in favor of the appellant on 19/4/2023. So now there are two documents that are
giving them the benefit of regularization would amount to exploitation and unfair labor practice. Full stop. In the facts of the case, the appeal is directed to be posted for final hearing on 13th of, on 21st of August, on 22nd of August, with following directions to operate in the meantime. 1. The university shall maintain status quo with regard to the service conditions of all the employees who are directed to be regularized. Full stop. There shall be no change in the service conditions of any of the daily rated employees to the detriment of, to their detriment. Next, the university shall make an application before the state government for seeking creation and sanction of posts on which the employees concerned could be accommodated. Such applications will be made within 10 days from today. Next, the state government shall consider such application having due regard to the operative facts. Further considering that the employees have put in long years of service and by following the principles and shall decide the application further by following the principles laid down in in Secretary State of Karnataka versus Uma Devi. Citation I will give and subsequent decisions. More particularly, paragraph 53 of the decision in Uma Devi Supra. Full stop. Such decisions shall be placed on record of the petition.
The latest judgment so far as Karnataka is concerned, Secretary Milad Malati Das versus Suresh and others.
Which one? The
2000 Milad 14, 13 SEC.
state government shall also take into account the decision of this court in
Malti Das case.
Malti. So and give the citation, give the.
Yes.
There's
While
also
taking a
decision of the apex
I'm
court which
just
cannot be
giving
done.
While taking a decision. In fact, this is required to be dismissed. But still we are.
This is also
Malti
directly
Das
daily wages.
Retired versus Suresh, which is civil appeal number 333-338 of 14 decided on.
7/3/2014.
This is, no, you are saying this court. This is old one.
Supreme Court, my lord, daily wages, regularization cannot be
That
done.
several decisions after Uma.
No, Milad.
Much water has.
My learned friend is not bound by the state
2023
government
decisions.
because there are 7 resolution at their financial resources. They
That
took a
it was
decision.
it was submitted by, on behalf of the respondents, that the judgment and order of learned single judge is proper in as much the financial burden of the salary of the employees is agreed by the petitioner to be borne by the university only,
Para 91.
as per their own resolutions.
Yes.
Why you are disturbing the persons who are since 35 years?
2019 was the status. Now much water is flown. We are being imposed with burden of 7 crores.
Madam, you see that appropriate decision is taken.
Yes, ma'am.
Yes.
Immediately.
Otherwise,
This
we'll
is
take a
exploitation. A model employer paying daily wages, taking the work from 8 AM to 7 PM
You
as a farm labor and coming before this court saying that 18 crores is there.
18 crores, not 7 crores. As on today, that would be the burden.
Let it be 700 crores, but you have exploited.
2019, the burden was just 82 lakhs, 81 lakhs. Now it has. it's
In
gone
fact, the very fact that you have continued them for 35 years shows that you are in need of their service.
No, sir. My lords, what had happened, there was a enactment, state enactment, asking us to continue them with a proper security. That's what the state.
In one
raised.
of the judgment in Gujarat High Court,
Yes.
leading the bench, I have taken a view that in such circumstances, it not only amounts to unfair level practice, but the requirement of approval of the state government is deemed to have been dispensed with. You can't raise a bogey of approval and all these things after taking services of 35 years. You could have, in the meantime, approached the government for seeking the additional setup.
My learned friend is applying for university. Board took a decision. I need not take the approval of the government because I am accommodating them within my financial resources. 7 resolutions have been passed. The learned secretary took the clue that yes, you are accommodating them within your financial resources. Therefore, the permission is not required. It is an autonomous university. Once it is established, the apex court said so far as service conditions.
The above direction does not reflect on the merits of the case of the other side.
Great.
We can, irrespective of your decision, we can take it.
Great.
Right.
Delay condon, all are appeal.
But only government could only be the aggrieved person, not the university.
Who is number 42? 42 is by the 42 is deleted for the time being.
Please.
With a delay of 2 days.
2 days.
We can condone it,
Condone.
but the court officer says that number 42 is not served, not represented. Who is 42? Karnataka Veterinary Cell this one.
Lords, they are formal parties.
Formal part, deleted. So in the IA, at the request of learned the applicant, this one 42 is deleted since it's a formal party, and the present CA can be, present IA can be decided in absence of this one 42. Delay of 2 days is condoned in filing the present appeal since sufficient expose is made out from the averments made in the supporting affidavit. Application is allowed.
The appearance matter, still number 14. So Shivraju MK.
This matter, previous occasions, the Honorable Court had directed to appear before, Tahsildar personally appear before this court.
Lords, there was a direction for the Tahsildar to be present and explain the letter 21/7/2000.
What is it about?
Lords, may I be permitted to file this affidavit?
In the name of.
There was a direction for the Tahsildar to be present and explain the letter dated 21/7/2023. Lords, I may be permitted to file the explanation by way of an affidavit.
File it. Learned additional government advocate, Ms. Pramodini Kishan. Files affidavit.
And also,
Which is taken on record.
and also, my lordship.
You on time?
No, my lord, in this occasions, they have not served the copy.
And also, my lordship. Panchayat Development Officer also filing the complaint.
The officer is present.
My lords, it's the affidavit by the Tahsildar who has given the letter, my lord, stating that the records are not available. I may be permitted to explain the same, my lords.
Then direction to remain present. So what is your stand?
Lords, the letter dated 21/7/2023 2023, my lords. I was
Go
supposed.
through, Mr. You go through and come. 22nd August, or 22nd July.
And also one more submission, Marshal.
Yes, next.
Respondent, one more submission. I have also filing the complaints, further
File
complaints.
it. Also, learn and record Mr. So and so, 4 numbers also files, which is also taken on record. 10 over to 22nd July. Next.
Pledge.
Number 15,
Serial number?
complaints in contempt matters, Muralidhar.
For complaint.
15.
Appeal for accused number 1 minute. Lord,
What is it?
Lord, the complainant, my Lord, had preferred the writ petition before this honorable court, my Lord.
I represent accused number 1, Miller.
Alleging,
Represent accused number 1. And he had arrayed the, secretary to the Ministry of Union Government as accused number 2. Lord, I don't think, my Lord, accused number 2 is really a necessary party in the sense.
it may be deleted.
What you complied with or not?
I have complied with. In fact, what had happened is this, my Lord.
What
Oh,
you-
The
compliance has
direction
been-
given by the learned single judge in the writ petition filed by him is to permit him to file the PhD thesis
What
again.
is your compliance affidavit?
I had filed the affidavit before the learned single judge himself, because we had taken time about, kindly see, Miller, along with my counter which I have filed. We had filed a memo producing all the documents, Miller, which has been produced by the,
You were to give the hearing, committee was to give hearing.
yes, what
Lord,
had happened, yes,
Committee
Miller.
has to,
The
committee
direction,
had to look into the contentions of the
It
petition.
is given or not?
It was not, contention was not
it
heard.
is not correct, Miller.
Hearing is given or not?
Hearing was given, but the
Then there
contentions,
is a complaint.
kindly similar, contentions have to be looked
Where is the
into.
decision of the
My
committee?
decision, my Lord, is that, my Lord, I had to place my thesis.
Where
The
is
committee had,
Where is the minutes of the committee?
committee's minutes, my Lord, they had,
Miller, I have produced it along with my objection statement.
No, page, show the page.
Miller, kindly go to page number,
33.
yes, Miller,
page number 30.
30, Miller. Page number 30,
30,
30.
33,
30, Miller, 30.
30, 30.
May I read, Miller? The committee welcomes Sri Ravi Prabhakar Hegde to the meeting. The chairman informed the candidate that the committee has an open mind and will consider the present thesis that he has submitted and take an impartial decision. He was asked to present the thesis and to provide clarification if any. The Lordship got it, Miller. Sorry. Along with my objections which I had filed, Miller. This was filed on 9/6/2022.
So that is done.
No, my Lord, there was a specific direction to look into the contentions which I had already taken, my Lord, before this court. My Lord, I had filed a writ petition, my Lord, several raising certain contentions, my Lord, against the respondent management, respondent institution. My Lord, that this honorable court, my Lord, was pleased to direct, kindly see para number 3 of the order, my Lord, page number 18. Lord, it will be important, my Lord, may I see, read from the first page, first para itself, my Lord. On the last occasion when the matter was heard, the learned counsel for the petitioner sought for an adjournment to seek an instruction from the petitioner as to whether he is prepared to submit the thesis before the committee, which was constituted by the fourth respondent demands to go into the allegations made by the petitioner against the second respondent. The learned counsel for the,
Not submit your thesis, what can be done?
Lord, the allegations which I had, please.
Did you submit the thesis, your thesis to committee?
Yes, my Lord, I submitted my contentions before the committee. Committee, my Lord, did not look into that contentions at all.
It is on the contrary.
Yes, my Lord, kindly see, my Lord, placing the submission on the learned counsel for the petition on record.
Sri
The writ
Ravi
petition
Prabhakar
stands,
Hegde, you are Ravi Prabhakar Hegde,
please, ma'am.
wanted a decision to be taken as contentions, did not agree to present the thesis,
Lord,
not submit the thesis.
I submitted the thesis. I submitted the thesis and I also submitted, Lord, I have submitted the thesis. That they did not deny also. I submitted the thesis on 21/8 itself, my Lord. On much earlier, my Lord, I submitted the thesis.
A second opportunity was given to the candidate to present.
I submitted the thesis, my Lord, on,
But he was insisting that he would listen the contentions first
Yes.
and take decision on that before presenting.
that was the direction of this honorable court. That was the direction of this honorable court to look into the contentions. After receipt of the thesis, they had to look into the thesis and give me the hearing for contentions. Lord, I had made some allegations, Lord, with regard to the mispractice or malpractice done by the respondent institution and also my guide while awarding while rejecting my PhD registration.
That was not considered at all by the committee. Committee was considered, the committee shall reconsider the contentions of the petitions after going through the thesis.
After going through the thesis.
Yes, madam, they went through the thesis, they submitted, they suggested me to make some changes in the thesis, which I did. After that, they had to look into the contentions of mine, which I had taken in the writ petition, my lord, which they were not ready to take the contentions at all.
The only directions in the judge order of learned single judge dated 17th April 22. Heard learned counsel for the learned advocate Mr. So and so for the petitioner and learned advocate Mr. So and so response 1.
Madhusudan Rao.
The only direction of learned single judge in his order dated 17th April 21, while disposing of the writ petition number 10738 of 19 filed by the petitioner, was to direct the committee of the respondent institute to reconsider the contentions of the petitioner after going through the thesis. You are doing PhD in what?
PhD in psychopharmacology, my lord.
The petitioner was studying was pursuing the study in PhD. It was further paragraph directed by learned single judge that the committee shall afford an opportunity of hearing to the petitioner and dispose of the matter expeditiously within stipulated time from the date of submission of the thesis before the committee. Full stop. In response to the notice of this court, respondent number 1 appeared and filed statement of defense. It contains copies of the minutes of the proceedings of the committee constituted for re-examination of PhD case of the complainant. Meeting of the committee was held on 28th October 2021 at 10:30 a.m. in light of the directions issued by learned single judge. Full stop. The minutes of the committee mentions that the appellant was welcomed in the meeting and was asked to present his thesis and to provide clarification if any. It is further recorded that instead of giving the thesis,
He has given thesis, my lord.
we do not know.
He has submitted thesis.
Lord, what happened is this.
He has already submitted thesis.
We are
May
not
clarify
concerned
me
with the any version.
Lord, on 27/9/2000.
We are not concerned with the version of any side.
Yes.
We go by what is stated. What did you write? Now, any interruption in the order will not be tolerated.
Please.
Is further recorded by the committee that the complainant insisted that his contentions should be heard and that unless the contentions are heard, there is no question of submission of thesis. The committee clarified that it is ready to listen to the contentions of the complainant during the defense after going through the thesis as per the court's order. It is recorded further that the complainant still wanted a decision to be taken on contentions and did not agree to present the thesis before such exercise. Not only that, it appears that the second opportunity was given to the candidate to present both thesis and the contentions, but the complainant received insistive that he would first submit his contentions and not thesis, full stop. In the circumstances, it could not be said that any willful contempt is committed. Any contempt, much less willful contempt, is committed by any of the respondents in respect of the directions issued by the learned single judge. The committee constituted for examining the PhD thesis in light of the directions of the learned single judge gave opportunity to the petitioner and recorded its minutes, full stop. The compliance could be said to have been achieved if the complainant has a grievance about the decision or conduct of the committee is open for the petitioner or to the applicable complainant to file appropriate independent proceedings before appropriate court oblique forum, in respect to which this court, however, does not express any opinion on merits. The contempt proceedings are disposed of as not entertained in view of the above facts and circumstances indicating the compliance.
Case number 16, Manu Prabhakar Kulkarni.
For the complainant's counsel. Manoj, in this matter, we need to comply, Manoj. There is violation, Manoj. Your Lordship may kindly grant a week's time or 2 weeks, we'll comply with the order.
23rd.
Can I just make one request, my lord? In the order dated 3/6, but your lordships have indicated that the direction of the learned single judge is not complied with. Would your lordships also indicate this learned order of the learned single judge as modified by the division?
Both the orders will comply.
Please,
No.
no. No, because there's a modification of the period. That's of course.
Comply then.
When learned advocate general.
I have
says will
nothing to
comply,
say. I'm very.
What more? IAS officer of the state said comply. What more do we do?
Please, no. Great.
Case number 17, Padmanabh.
Complainant. Lord, I have filed a EFR.
Pardon, yes.
Releasing of EL encashment, my lord. EL encashment not released, my.
It's this. Let's, I would request for kindly pass over of this matter.
Password.
Pass over.
Password may not be possible. 24th of July.
Obliged.
My lord, maybe have it on 23rd of July.
23rd of July.
Please.
Case number 18,
My lord,
Manmohan.
filed, I am, my lord, seeking to recall the order, my lord. Attempt, dispose as we are not complete office objections, my lord.
Who appears?
And my lord, I maybe.
Where are the directions?
My lord, passed on, my lord, order. My lord, on 8/4/2024, my lord, order was passed for non-compliance.
Where is that order? Order is not complied with. Where is that order?
My lord, for non-compliance of office objections.
Office object.
Office object.
Office shall be
Office
complied within 3 weeks.
My lord, we have complained. We have filed IF seeking for recall, my lord. It is dismissed as dismissed, my lord, for non-compliance.
So file IA.
Please, my lord.
Where is that IA?
My lord, I have filed on 10th June, my lord.
3 of 24.
Please.
Heard learner, IA 3 of 24. Heard learner advocate for respective parties. Come on, this, you are appearing. You are
That's
appearing.
up for state government. There's also KIDP.
It appears that this contempt was dismissed.
Please, my lord.
Contempt petition was dismissed for want of compliance of the office objections. Full stopping. Learned advocate, while pressing the relief in this IA, submits that whatever office objects are left out from being removed shall be removed within the time which court may grant, on condition that the paragraph, all office objections remaining to be removed shall be within period of 4 weeks, the present, this contempt petition shall revive.
My lord, I may be permitted to withdraw this contempt petition and permitted and liberty to file application in writ appeal, my lord. Writ appeal is pending, my lord.
Withdrawing this.
Please, my lord, I will withdraw this and I will file, liberty may be granted, my lord.
After restoration, you want withdraw?
Please, my lord. I will withdraw and permit and maybe
restore.
Liberty may be granted.
At this stage, learned advocate, it is listed today. Contempt is listed too. After the passing of the order, above order, of restoration of the contempt petition, learned advocate for the complainant stated that he has instructions to withdraw the contempt petition.
With
Dismissed
liberty,
as withdrawn.
with liberty, my lord, to file up.
No liberty.
No, my lord, I will file application in the writ appeal, my lord. Writ appeals are pending, my lord. Writ appeal is pending, my lord. In that order, interim order has been passed. They have, respondents have violated the
This
order,
is,
my lord.
this is an interim order
Please, my lord.
stating that it seeks permission to withdraw the contempt petition, stating that the order brought under contempt is an interim order and that the complainant shall approach the learned single judge,
Division bench.
division bench.
Permitted to file application in division bench. Division
Shall,
bench.
shall approach the same court where the parent proceedings are pending.
Please.
Reserving such liberty, paragraph. However, without expressing any opinion merits, the permission is granted to withdraw the contempt petition. Disposed of according.
Appear for 6 and 7 months.
So who, or
Respondents
learned
is-
advocate so and so, and learned additional government advocate.
6 and
19 also same.
Please.
And same, withdrawing.
Same, my lord.
All the same order. IA 3 of 24, 18-2 of 20. All right, Adu go ahead. Then IA 2 of 24 will not survive in 18, and in 19, IA 3 of 24 will not survive. Order will be in IA 3 and IA 4 respectively. Yeah, yes, next.
Number 20.
Petitioners, my lord, this is a matter for preventing encroachment on lakes and stormwater drains. And my lord, there was a series of actions passed by my lords, and as per the last set of directions, some compliance reports have to be filed. If they are filing the same, because my lords, they had undertaken that every week they will, every month they will undertake some number of lakes to be cleaned up and report on that. So on that, the latest update has to be filed by BBMP.
Appear, what has happened, there are series of directions, Manoj. In fact, the direction itself, order sheet itself runs to around 30 pages in this, 200, 300 pages, the order sheet. What I have suggested, Manoj, is to make what are the orders, what are compliance, what is to be done. Insofar as answering my learned friend, Manoj, with regard to maintenance, like there are 200.
Will help the court also.
No, that is what, Manoj. Just to answer immediately, immediate solution also, Manoj. There are around 205 lakes in BBMP jurisdiction, Manoj. Now, what has happened pursuant to 2020 order, Manoj, this court said no agreement to be given to any private party for the purpose of maintenance. We also have taken a conscious decision that we will not give it to any private party. But the court also has permitted to take funds from them, Manoj, from the private party, whoever is coming. So in that regard, we have framed a policy, Manoj, which is placed before your lordships, Manoj. In terms of that policy, Manoj, where the owner of the lakes are the government, the BBMP maintains it. But what we will call is call for tender insofar as from the private parties, because earlier we used to take funds. We don't want to take funds because
For maintenance.
maintenance, there may be misappropriation from the BBMP, or what we'll call for expression of interest from various people of the 205 lakes on a tender wise, and we'll specify the work to be given, to be done. Whoever gives the expression of interest, Manoj, we'll give it to them. Only thing, they'll do the work, but it is under our control, Manoj. Because nearly every year, the cost of maintaining these lakes is around 30 crores, Manoj, which is, now if they come forward, they can maintain it, but ownership and maintenance will be with the state government and the BBMP, Manoj.
So with such policy, this can be disposed of.
That is one aspect of it, Manoj. I placed the policy before your lordships also on record, Manoj.
My lords, we need some time to, 1 minute, so we need some, so 1 minute. We need some time to respond to that policy, because the concern should be that maybe in few lakes, there are resident groups and neighborhood watch groups who are very vigilant on the lakes. But every lake, 200 lakes in Bangalore cannot all be given out. Then what is the role of the BBMP? So we would like to just respond to that policy, so that if we have any suggestions or submissions, we can make them, and then my lords can take a view. And in the meanwhile, the ongoing removal of encroachments on the lake and stormwater drains has to keep happening, because ultimately the responsibility is of the BBM.
How much time you are?
Well, insofar as encroachment, Manoj, we are doing, we'll place the status report. There's no problem, Manoj. We are interested in our like, if they have any suggestion, if they show any encroachment to be done, let them give it, tell us, we will do it. In fact, Manoj, the officers have met her, my learned friend personally, shown
Yes.
the policy, taken her.
In fact, the policy, we are keen, we are keen that a policy where neighborhood committees are involved,
Right,
it will in
the-
fact assist the maintenance of the lake.
Subject,
In 20.4, I already filed my response to
the subject matter of this public interest petition is the reservation, maintenance and upkeep
And upkeep.
of the lakes situated within the city of Bangalore.
Please.
Full stop. The orders are passed by the board time to time, giving directions to the respondent Bangalore Braj Nagar Palike and other authorities to ensure the maintenance and cleaning of the lakes. Full stop. When the petition comes up for consideration today, learned Advocate General appears to make submission that the state has formulated a policy whereby the lakes are proposed to be, certain lakes are proposed to be
All the lakes in the Bangalore.
lakes are proposed, not lakes, only lakes. Lakes are proposed to be handed over to private party for the purpose of maintenance and preservation. Full stop. It was submitted that since the lakes are several in number and it will entail huge expenditure for the Nagar Palika, such a policy is evolved in larger public interest. Full stop. Learned Advocate General, assisted by Learned Advocate for BBMC, seeks time to produce the policy on record of the proceedings. Paragraph. Time is granted. The petition may next come up, shall be next posted on when? 24th of July.
Please.
24th of July. In the meantime, as agreed by the respondent, Bangalore Braj Nagar Palika, the work of cleaning the lake wherever necessary shall be continued.
Manoj, just a date I was requesting, instead of 24th, maybe 31st, the week after that.
31st
31st.
shall be continued. And lakes shall be properly maintained.
One, Your Worship, may kindly reserve liberty to the BBMP to call for expression of interest of this for maintenance this lake from 205, for 200 maintenance of this 205 lake. We will not finalize, my lord. We'll call for the expression of interest. We'll place it before your lordship.
Manoj, let it be only from community groups. Ultimately, we want community
them get the
groups
fund.
to-
Let the policy come.
Policy is already placed before your lordship.
Already placed.
Already placed.
So they
Let it be from community group.
Yeah. 22nd February.
Start for any application to.
Let them suggest, let them not argue. Let them give solution. Let them give solutions.
Three 44 of the new act prohibits now. They can't have any private entity, 344 of BBT Act. I filed my response for the 20.43 number.
22nd February 2024, we have placed the policy. If they have any suggestions,
It's not permissible.
You may not answer the query of the court. You are free not to answer. You are free to ignore the query of the court. But please permit the Advocate General to argue. It will not be taken up before 31st. And they will permit, you want to permit. Let the policy, let the have their.
let them have the reply. That, please, Mullah, I bow down to your
We will
lordship.
give our
31st
suggestions.
will
Manoj.
grant such permission.
Yes.
And if there's any suggestion, we will incorporate it, Mullah. We are not against it.
So you ready with the suggestions?
Yes, we, in
Because the
fact,
policies, you also, Mr.
Yes.
Council. Whatever suggestions are there, we'll consider it.
And we'll consider and we will accept it also if they are in the interest, public interest, Mullah.
that's all we want. We
Now, when
want it
the-
in public
when the
interest.
Policy on record.
22nd February 2024, it was filed along with an affidavit, Mullah.
27.
22 February.
No, we
24.
have something of 20th March.
Just, no, this is the one.
Thank
I'll just give you. I'll give you one more. What is
Sir,
it?
where is-
Take this.
Policy, it is on the.
That's-
20th March.
This is the
So
one.
it is there, you go through, Mr.
For that, I given the.
No extra copy,
They are
their
entitled.
policy.
They
In
know
fact,
for-
I'll give one more copy to my learned friends, my lords. Let them also.
They know for my response.
I give my copy. Photocopy.
No.
You also give this can be the fourth.
And in fact, my lords, if I may suggest, my lords, they have got February we have given. Next week, my lords, if they want, let them sit with the officers, come up with a suggestion. If any improvement, we'll place the final
Lords,
policy.
prior to
How
31st,
many-
we'll give our suggestion.
How many lakes are there?
My lords,
205 in band.
my lords, let me make my one submission. In principle, in fact, we have met with the BBMP and their council. What we suggested is that in some of the lakes, there are community groups and neighborhood groups. They are not commercial private entities. These are community resident groups who are very keen and to ensure that the lake is protected from encroachment, from any dumping, etc. And in those cases, certainly it would help if these community associations are there and having some MOU with the BBMP to maintain the lake.
They are the cooperative societies.
They are residents associations,
So
residents
group
group
of
of the residents of the neighborhood.
My lords,
In those
We are
cases, it will
welcome,
be
we are
helpful.
welcome to that. Only thing is, my lords, tomorrow, once we give it to them, when we call expansion of interest, let them give it. Only question, they have to invest money to keep it. Tomorrow, they should not say that we'll maintain it, but we'll not.
We may categorize the.
Yes.
Because we are open to it, my lord, as long as,
That extent, it may be a good suggestion.
my lord,
to
as
that
long as
extent.
they're ready to maintain, invest money,
Larger lakes, you may invite expression of interest.
everybody will invite, my lord. We have no.
For small
No, it
lakes.
can't
become-
be, my lords, residents groups and associations should be taken as a separate criteria because they may spend whatever they need to for their,
For example, I'll give, my lord, just to, so the, for example.
Your policy should not be a tool for commercial exploitation.
that's our only concern. That is our only
In
concern.
that is stated in my
Our
policy
only
itself.
concern.
That by virtue of that interference, you will keep.
Just one sentence, my lord. Just to answer, just one sentence. Entity shall mean group of citizens, association, including residents welfare association, cooperative society, corporate companies, NGO with duly registered. Everybody is covered, my
But
lord.
not corporate companies. That is our concern.
Not
That is our
corporate
only-
we need money, my lord. Tomorrow the corporate
We'll consider.
We'll,
Also, they
Great.
want to construct, construction cannot be permitted like.
No, construction cannot.
Your lordships kindly,
Reduce the lake area. Prohibition is there.
We'll go.
my lord, item 21.
in
Lordships. Lordships, permission to mention a matter.
Yes.
My Lordship, so say item number 38, so say, if your Lordships recollect, in fact, this is that removal of, okay, the State Pollution Control Board chairman's matter, where your Lordships had specifically, you could say, listed the matter today. And it's been almost now, say, on the three occasions. His tenure ends in November. Otherwise, the whole petition itself will become infructuous, your Lordships.
It will reach, mister. We are
Please allow.
hearing 38. What is the number going on?
20, your Lordships, as of now.
It will reach. Let us wait, yes.
Please, your Lordships.
This the list one, passport matter, seal number 1. Mr. Malli Anand Kumar.
Have the copy of the complaints of affidavit on them. Yes, yes. Status quo with regard to the revenue entries have been maintained. And also in all column 11, dependency of the writ petition has been entered. Writ petition, yes, your Lordship. Writ petition is still pending, your Lordship. This is against an interim order. The order is towards the official respondent, it is that we shall maintain the status quo regarding the revenue entries with regard to the said property for which they had sought for a stay.
May I Lord, I bow down to that. Just your Lordship, kindly hear me for 2 minutes. Lord, the order initially said, needless to say, no further action can be taken in furtherance of the land tribunal order. In para 4, there is a categorical admission that the LRs of the deceased have sold the property in favor of third party. So one contempt is by the LRs who are all parties here from 1 to 9, respondent 1 to 9. That, my Lord, I leave my lords whether they should be called or what action needs to be done. That I leave it, or whether Lordship will give us some liberty to take it after the writ petition, but that is different. So they are aware a transaction of a sale has happened in spite of a interim order. Then para 5, yes, after interim order, a sale transaction has happened out. Then, my lords, they have culled out the subsequent maintenance of status quo. Then they have produced R1 and R2, which is of 2020. The sale transaction happened in 2022, 24 to 2022. The sale that has taken place is in favor of one, they have shown that transaction there. Grand Sky Infrastructure. Next, your lordship will see in the page 2 of annexure R1.
No, that, I will
No.
clarify on that point, your lordship.
I will come. Page 2, your lordship will see. They have entered the name of the transferee. This, they say, we have just made a transaction entry, but we have actually not effected the transaction. And in para 5, they say that we have falsely mentioned before the court that they have effected. Kindly permit me to show page number 89 of my contempt petition. Annexure K. Is a form number 12, copy of mutation register. Your English translation is at page 89. Down, your lordship will see as per land tribunal order transfer. Lord, I'm now not on formality. What I am, Lord, want to tell your lordships is they have made a false allegation saying that we have falsely stated. Trying to suppress
clarify.
something which they have done. Now they are assuring the court that the name, the subsequent name will not be entered and the same thing will happen. Lord, I bow down to that. But we also have to keep in mind that there was a violation of the interim order. Respondents 1 to 9 have not blatantly violated. They are private parties, they have come on record. They have an advocate who they are represented and still they have sold the property. There are parties in the writ, there are parties here also. Lord, notice your lordship had not, the lordship wanted to first see what they wanted to say and then
I will,
issue notice to them. Lord, it is.
to the
Lord,
submissions of the
come-
learned senior counsel, I will just clarify one point. That annexure K, what they are selling, your lordship, it is the entry from the Bhumi software. When a document is presented for registration, automatically a J-slip is registered. Now the official has to verify and give the thumb, which we have not done. At that juncture, we have stopped the transaction and yes. Yes, your lordship.
But
Order.
the interim, please. Lord,
As far as the official respondents are concerned, we have an order that we have to maintain the status quo with regard to the revenue entry. That was passed when they filed an IA before the learned single judge. And on that day, the learned single judge passed an order saying that the official respondents will maintain status quo. That, to that extent, we have maintained status quo, your lordship.
May I persuade my lords either to issue notice to R1 to R9. Sorry, my lord, R2 to R9, R10.
Yes. Number 83. 230 met. Nagarajappa.
Appellant in this, my lord. My lord, I pray for a week's time in this, my lord. I pray for a week's time in this, my lord, because, my lord, in the last date, the matter was heard, my lord. It was instructed, my lord, to secure information with regards to the departmental examination of the respondent number 3, my lord. I've informed the appellant here, my lord, still I have not secured the information, my lord. For that reason, I pray for a week's time. Please.
It's 83. Now 84. SB Mukanappa.
For appellant, short accommodation, my lord. Senior is not inconvenience of senior, my lord. Seventy-six and 96, my lord. Hello? What? 10 minutes. No. My senior applicant. Inconvenience, my lord. Senior is not very well. Yeah. Almost.
Uh, 85. So Vasant Kumar HD. I'm the complainant in this case, ma'am.
Compliance affidavit has been filed. Consideration is at page 48 R7 minutes. It's dated 12/3/2024. The compliance affidavit.
Not yet compliant, madam. Liberty may granted to challenge us. It's number 86.
Lordship, I appear for the appellant, Lordship. Lordship, court is not audible.
Which one?
I appear for the appellant in writ appeal. Lordship, I pray for a short accommodation, Lordship. The petition, first respondent has filed certain documents. I have to get the instructions with respect to that. He is trying to introduce new set of documents which are not part of the records, Lordship.
This is the tender.
Tender matter, my lord.
Cancel.
Notification was, award was issued to me. And my lord, thereafter 3 months, though there is an order of status quo, general manager of the first appellant cancelled the tender without authority of law. Section 14 of the my lord, KGT fact is very clear. And tender document also. But kindly see the notification of award, my lord, issued to me on 2/3/2022. And I have paid a security deposit also.
It has been returned, Lordship.
Learned single judge, having regard to the section 14, rule 14, 207, kindly see. There are 3 items, Lord, tender document says, Lord, ICU cost 628, portable X-ray machine 165, syringe pump 625. Other 2 items, Lord, they issued, Lord, work order also. For me, they have not issued work order. Annexure G page 207 is similar notification of award, Lord. Kindly see. Issued by Managing Director KSMCL Bangalore. Then, my lord, I paid the security deposit immediately. Page 188. Then agreement is also submitted. Work order is not issued. I approached the court. Court issued an interim order to maintain status quo. In spite of that, my lord, after 3 months, my lord, on 3/11/2022, my lord, general manager had cancelled the notification of award.
When do you, if she wants time?
My lord, difficulties, my lord, I have invested 10 crores for purchase raw materials. 45 days I have to supply for them according to.
You are for whom?
Lord, I am for the first step and succeeded in the writ petition, Lord. After the Lord, award of contract, I have to supply it within, my lord, 45 days.
Lordship. Lordship, one submission, Lordship. It is my specific case that the government has approved
Madam, are you arguing or seeking time?
I am seeking time, Lordship.
When do you want?
Lordship, I pray for 2 weeks
2
accommodation,
weeks
Lordship.
can't be granted. 2
Kindly
days
have
can
it next week, Lordship.
2 days can be granted.
Next week, any date, Lordship. Any date of,
Which date? It's the last chance we are giving here.
16,
Please,
my lord,
Lordship.
16th at 2:30, my lord. At least. Because, my lord, difficulty, 45 days I have to supply it, for which I have invested. After 3 months, my lord, they cancelled the my lord, tender. That too by general manager.
18th or 16th?
16th, my lord.
18th or
18th.
16th?
18th, Lordship.
That she says 18th, my lord, 2:30, 18th.
18th.
18th, my lord, at 2:30, my lord. Otherwise, my lord, the difficulty I have mentioned to your lordship yesterday also. I request your lordship, my lord. From the decision of the single judge in other case, when notification of award is issued under section 14, they cannot, Lord, cancel the.
We'll see, examine.
Yes, ma'am. 18th at 2:30, I request you, because of the reason, because of, but my client invested 10 crores, Lord.
First part of your request is granted, second part will be granted on 18th.
I highly obliged. Only I request your lordship is that, Lord, since I made an attempt to, Lord, for this court, 2-3 occasions never reached. Then my lord said yesterday, today at 2:30. Only my lord appeal to your lordship is 18th at 2:30, permissible. That's all, man. I'm a humble petition.
We said on that day will be granted.
Yeah?
On that day it will be granted.
Wait.
It's number 21. The Siddharth Suman.
Let's say for the petitioner in first case. Let's on the previous occasion, my lord.
So who is appearing for number 3, Chitrakoot Steel?
My lords, we wish to change our advocate, my lords.
Who appears for number 3?
Lord, I appear for respondent.
So you have given up your right to receive?
No, I am not given. The writ petition direction is to, the writ petition, my lord, page 15 to 18, the direction is to
We
pay.
just, this is so complicated, so again recollect. Complicated in terms of how to grant relief or how to dispose, not otherwise.
There is a government order to that effect.
You are for whom?
I am for T.G. Satyaprakash, who filed the writ petition, who is a person, my lord, in whose favor the company gave authorization, and I brought the money, my lord, from various investors, and company only lent the name. And my lord, I personally bid in the auction. My auction was accepted. Ultimately, my lord, they did not this thing. Therefore, my EMD was lying with them. They did not refund the money. They illegally tried to forfeit. I filed a writ petition. Writ petition came to be allowed, and that amount EMD was paid to me. Thereafter, interest portion was remaining to be paid. For that interest portion, I filed again a writ petition in 8533. That writ petition came to be allowed. And thereafter, my lord, the government passed a GO directing to pay the money.
And thereafter, I had to move the contempt. In the contempt, my lord, the government deposited the money before your lordships. Now, after all these things, my lord, one person by name Praveen Kumar filed a writ petition. That is the tagged writ petition. In that writ petition, we have compromised because he was one of the investors. And we have compromised. At this point of time, Chitrakoot, my lord, the company has filed a fresh writ petition challenging seeking review of the order passed in 8533, in which, my lord, there was a direction to pay me, which order has been completely to the extent of 98%, except withdrawal of the money. My lord, last occasion, my lord, one advocate appeared for Chitrakoot and he was making the submission. Now, I don't know this gentleman.
My lords, the advocate did not pass on the instructions correctly, my lords. So we wish to
We are
change
not
the-
giving any audience to you. Is he authorized to address the court?
Sir, in the
Will
course of-
not absence. We can't go on part in person who are not authorized. No audience will be given. This is the court of the lawyers. Lawyers are the officers. Unless party in persons are authorized in form number 6, we are not going to give any audience to any party in person. Learned advocate for response 3 is absent. In that we put up on 9th August.
Obliged. Well, at respondent number 3, I am present.
We'll
The
see.
petitioner for the
So only claimant is number 3 now.
claimant is number 3. I am here. I am not absent. Now the
Yeah.
company's
First petition,
representative,
I am the
that's
claimant.
petitioner in writ petition number 27261. His advocate, my lord, I don't know what has happened between that petitioner and the advocate. He is the party in person who is before your lordship.
That is the company Chitrakoot, man.
You are for petitioner.
I am for petitioner Praveen Kumar. Lad.
So why do you want that the interest should be paid to number 3 only?
My lord, I have invested the money with them and now the respondent for such a.
It is between you and number 3.
That's right, my lord. Now he said that
We can't, first relief in the petition, we can't be granted.
Lord, it is the inter se dispute between
Yes.
the respondent number 3 and that petitioner.
That's right.
Lord, we-
Compromise.
Let here we have filed the.
We have filed,
Have you compromised?
Yes, my lord, we have filed the compromise petition.
Lie. What is the compromise?
We
Otherwise, no relief can be granted.
have already filed, my
Right,
lord.
the relief. Unless you are compromised, we will take.
On 10th March 2022 itself, we have filed.
What is the compromise?
At page 3, paragraph 3, we have said what is the money that we are entitled, which is before this honorable court. Praveen Kumar, Ramanna and Nandini.
You are referring to 4th respondent.
Please, my lord, the money is with the 4th respondent.
Money is with-
We paid to the 4th
Now
respondent.
today is in court. It is
Court.
not with me.
Please, my lord.
It is
We
with
said that if
court.
the money goes to the 4th respondent, we will take it from the 4th respondent.
He is walking out of the dispute. You are walking out of the dispute.
My lord,
We are still claim over the money.
I had the claim over the money that is lying in deposit.
You are claim or not? You are claiming that money?
Yes, I am claiming that money. Because the writ mandamus is to pay money to me. Well, at 8, your Lordship kindly turn to page 15 of the paper book in writ petition 27.
may I clarify,
Here,
may I clarify.
8533,
Initially, the company represented by
please,
Satya
my lord,
Prakash.
come to page 15, my lord. Page 15. Page 15. This writ petition is the mandamus which is sought to be worked out. This is the writ petition under which, where I was the petitioner, a direction has been issued to pay money to the government. That amount is lying in court. Now, that amount, my lord, is to be released to me. That's all. That is all the issue. At that point of time, the company comes before the court and files a writ petition seeking review of this order. That is writ petition 27261. So far as the claim of Mr. Praveen is concerned, Praveen, who is one of the investors, my lord, and me, my lord, who is one of the investors, and I collected the money and invested it, my lord, we have compromised. That is the compromise petition. Now today government's apprehension is that I should not have any claim over the government after release of the money.
No, that's not.
Or the company should not have any claim over the government.
May I make a submission?
And I have also filed an affidavit indemnifying everybody, my lord, including the government, against claim by anybody, including the company. As per your lordship direction, that affidavit of undertaking.
The lordship may kindly peruse the order in WP number 11-321 dated 13th January 2013.
In fact,
35.
you never had a claim.
My lord?
You obtained the finance
Yes,
and participated in the tender.
tender,
So
in
now
the name of the company.
your role is over or not?
My lord?
Your role is over or not now?
My role is not yet over. My role will come to an end once the direction given in 8533 is complied with by the government. Government has complied with that, and that money is lying before your lordship. After that, my lord, the company is disputing, for which I have given an undertaking before your lordship that if any claim is made by anybody, including the company, against the government, I will satisfy that.
That's not that. The lordship may kindly see in 11-321, the initial writ petition filed by the company represented by Satya Prakash.
Correct.
He was the authorized representative of Chitrakoot. Your lordship may kindly peruse Annexure B, page number 19 of the paper book connected.
Earlier petition.
Earlier petition. Your lordship may kindly see the cast title. Chitrakoot Steel and Power Private Limited, represented by T.G. Satya Prakash. And this lordship may kindly come to page number 39. There was an order. In the circumstances, writ petition is allowed. The respondent shall refund the amount with interest 12% from the date of deposit till the payment of EMI, which we have complied with, except the interest. Thereafter, Lord, Satya Prakash in his individual capacity filed a writ petition seeking release of this interest portion, 3 crores. The last may kindly come to page number 15 in the very same paper. Page number 15, writ petition number
For interest.
for interest.
8533.
85. Here, company was not a party. He himself filed.
But this order stands.
That is the order we have also challenged.
Thereafter, now there was an order.
Then review.
Then review. We have filed review, and company has also filed review. Subsequently, they have withdrawn the authorization granted to Satya Prakash.
What happened in review?
It is pending. It is tagged with this. Our review petition is pending before this honorable.
In my petition,
And-
we have challenged the very order.
You are nowhere. That is the dispute between Satya Prakash and
No. We have
Praveen
challenged
Kumar.
that
They are
order.
not the,
Review is also pending.
yes, it is tagged with this connected matter.
And what is other matter is pending?
Other matter is by the company. Company has filed a writ petition to review the earlier order, saying that we have withdrawn authorization granted to Satya Prakash. Respondent number 4 here. Therefore, my concern, our concern is,
We'll dismiss your appeal, your petition.
yes,
My lord, here,
they
my
are
lord,
not
my
concerned
lord,
with.
we have challenged the very order, my lord.
We'll
This
deal with review.
8533,
8533 of 2017, we challenged saying, in first petition is filed by the company, this petition by the individual, we apprehend that we may not get the money.
So
Hence,
what-
please review the order.
Mr. Mahindra, what are you seeking in review?
Review to recall this order.
This 858.
Yes, my lord.
8533 order.
8533.
Not to be, my lord, reviewed on the ground.
If it is recalled, then what will be?
Now, we are ready to pay the amount to the Chitrakoot or whoever they authorize. Because we are bound to pay the money to the company, not to anybody.
Now the issue is only this. So far as 8533 is concerned, that writ petition came to be filed on the authorization of Chitrakoot by me. And Chitrakoot permitted me to file the writ petition and get the interest amount. When that writ petition is allowed, when the amount is deposited, because it is my money, I have collected. Chitrakoot is only a name lender.
That we
That's
do not
the
know.
issue.
So far as
Therefore,
state is concerned,
Chitrakoot is only a name lender. Therefore, my lord, today, my lord, after my effort,
In the
and
whole,
Chitrakoot authorized.
Now, go to your petition.
yes, ma'am. 36,679 of 18. The prayer column is at page 23, my lord.
Prayer, let us see. 36679, your prayer.
To recall, set aside the order dated 20, my lord.
That can't be done. No,
My lord, no,
such
the-
a prayer cannot be granted. Set
To-
aside the order passed by the
Lord,
court,
here, my lord.
by coordinate bench in another petition. How can this prayer be granted?
My lord, here, my lord, my humble submission is that initially, the respondent for filed in the name of the company.
This
Then
prayer
he
can be-
filed in the name of the individual.
This
It is
prayer-
my money.
Kindly listen. This prayer can be granted only in review petition, not in writ petition. So first prayer, we are not going to grant. Number two, read other prayer.
My lord, may I submit, my lord? It is my hard-earned money and it is nobody's claim.
What cannot be granted in writ petition cannot be granted.
My lord, now there is a compromise between the fourth respondent and the petitioner.
What is the next? Yeah. What
The
is the next? What is the
Writ
next?
of
prayer?
mandamus are such that orders directions to the respondent 1 and 2 to pay the sum of rupees 3,04,000.
That you can't dictate the court with such a prayer.
My lord, this is the money that is with the government and the, my lord, that is the amount that has been granted to the Satya Prakash.
Where is?
My lord, even review can be maintained. I have the judgments, my lord. If some time is given, certainly I will be able to convince my lords. Sometime, my lord. I have the judgments. My lord, this court and Honorable Supreme Court. I will convince about the maintainability of my petition.
writ petition.
Who?
Praveen Kumar, petitioner in this petition.
My lord, we are.
He is seeking review of that writ petition wherein he is not a party.
We are proposing to deal with your review application.
Please.
And in that, we will work out the rights of the party.
Please.
In whatever it can be worked. Prayer number 3 is, advocate is not there. So we postpone for a
Please.
30th July. In view of since the presence of learned advocate for number 3 was awaited in vain, in order to give him the opportunity of making submissions, stand over to 30th June.
Lord, we are not,
Today is
petition, but I am not the counsel for the petitioners. I am the counsel for respondent T.G. Satya Prakash.
Not so far as.
R3 is here. I am not the petitioner. I am respondent number 3.
Understood.
Therefore, I should, my lord, the order should not,
No,
Lord,
No.
Petitioner in writ petition 8533 is not there. 27261. He is not there.
Petitioner is not there.
Petitioner in writ petition 27261.
Learned advocate for the petitioner in writ petition number 27261 of 19 is not present. In that view, in order to give him the opportunity to make submissions, 10 to 30 actually.
Lord, what, 36679, Lord?
Pardon?
That petition.
My lord, we will convince your lordships, because we are the poor investors, my lord, and we will convince, my lord.
You want to argue?
No, next time with judgments,
Today you want to argue or next time you want to argue?
no, next time I will argue, my lord.
Obliged.
It's number 22. The metric.
This matter for the impleaded parties, my lords, on the last date, if
My lords,
may
this matter
recollect,
pertains to the manual
manual
prohibition of
scavenging.
manual scavenging act.
on the
My lords, on the
date, my
last date
lords
of
had-
hearing, learned senior counsel, my lord, she's representing for respondent number 7. I don't think it's
Yes.
a petitioner.
No, I'm an impleaded party.
She's impleaded herself in one of the matters. My lords, all these matters, my lords, pertaining to implementation of prohibition of manual scavenging act. Various affidavits have been filed before my lords, and we have complied and we are complying with the act, my lords. There are almost four matters listed before my lords. My lords, I have made a small compilation of prayers and complaints.
On the last date, my lords, in fact, I had submitted that on their compliance report, we want to
May I-
submit. 1 minute, ma'am. So on that issue, the one issue we pointed out was that even the state level committee, which is required to be held twice a year under the act,
That you have to take it.
on that, a
Yes.
memo has been filed.
Yeah, we have fixed a meeting, my lords. That's what I wanted to submit. Meeting is now fixed, my lords, on the 31st of this month, 31/7/2024. Meeting is fixed, my lords. We have served a copy to the other side.
In the memo that they have filed with the meeting notice, if my lords would just one submission I want to make on that point. The section 26 states that the state monitoring committee meeting shall be under the chairmanship of the chief minister of the state or any other minister appointed by the chief minister, if section 26 is seen. And along with the chief minister, one of the ministers has to be the minister in charge of scheduled caste welfare. The meeting notice that has been shared reads as follows, that the 7th state level monitoring committee meeting shall be convened on 31/7/24 under the chairmanship of chairman, state level monitoring committee and honorable minister for social welfare department to please attend the meeting. Just want to make it clear that the social welfare minister anyway has to be there as per the statutory requirement. Chairmanship has to be under the chief minister only, then the seriousness of the task will be there.
The meeting, yes, then we'll see.
Yes, that meeting should
My
be
lords,
done.
I would beg to differ from the learned senior counsel. Section 26 is very clear, my lords. May I read section 26 to my lords? Every state government shall by notification constitute a state monitoring committee consisting of the following members, namely, the chief minister of the state or a minister nominated by him, chairperson expiration. Second, my lords, various other minister in charge of social welfare, chairperson of state election commission. Now, my lords, chief minister has now delegated the power to the minister of social welfare and we are conducting the meeting. The meeting is fixed, my lords. I don't think we are in violation of any.
My lords, may I just make one submission? My lords may see section 26. It cannot be delegated to the Minister of Social Welfare. Minister of Social Welfare is one of the additional ministers. You can delegate it to another minister. Minister of Social Welfare is one of the ministers under 26B, who is in charge of scheduled caste welfare issues. If the chief minister cannot attend, chief minister can nominate any other minister. But to say that the social welfare minister will be nominated, it goes against the provisions of the act.
We'll consider later.
Let them report after
My
this
lords,
meeting
my
is done.
respectful submission is learned senior counsel, my lord,
Learned,
representing
petitioner.
respondent number 7. The petitioners are not,
This Mannapura
please.
stated that the meeting of the monitoring committee.
Please state level. monitoring committee.
Under Section
26 of the Prohibition of Manual Scavenging Act, my lord.
Implement of manual scavengers and construction of dry latrines into bracket prohibition bracket for Act 1993, is scheduled to take place on
31st of this month.
31st of July 2024. In that view, go to 9th of August.
And let
Grateful,
them-
grateful.
Let them thereafter
Law is
give
the
the report of the
2013 law,
meeting.
my lord.
Let them thereafter give the minutes of the meeting.
That will place it on.
My lord, the law is the 2013 law, my lord. My lord had mentioned 93. It is a 2013, the Prohibition of Employment and Manual Scavenging Rehabilitation 2013 Act.
2013.
13 Act.
Great.
This prohibition of employment as manual scavengers and their rehabilitation.
Rehabilitation Act 2013.
Grateful. ma'am.
Grateful.
Number 23.
My lord, I'm for the petitioner in this case, my lord.
For the petitioner's counsel.
My senior counsel, Mr. KT, is present in the court. He would argue this case today, my lord.
My lord, appearing for the state, my lord. This
There
matter.
are several applications. I think in the first instance, those applications could be allowed. We have no objections to that.
A date may be fixed for hearing of this matter, my lord.
Impleading applications are there. We have no objection to those impleading.
Impleading it.
I'm pleading application. I'm pleading for respondent number 11.
IA number.
IA number is.
I9.
But IA number 14 of 21,
IA number 5.
IA number 19, several are there. Lord. I think those may be noted down later by the office. I think a common.
So both are allowed.
Pardon?
Both IA are allowed.
All IAs.
In, my lord, in 500, with petition number 511.
Main will be taking up on 1st of August.
But as far as the pleadings go,
All impleading allowed, all to be allowed.
All impleading. All impleading.
all implead.
All, how many are there?
At least half a dozen are there. 9, 14, 21.
14, 1.
What is the subject matter?
The subject matter is under the Karnataka Apartment Ownership Act. A deed of declaration is envisaged under section 11. That deed of declaration itself is used to have unregistered sort of associations which run the associations in the buildings. That is not permissible. And that has also been confirmed in the counter filed by the state government at para 20.
Yes. We have
One
five.
submission, your lordship. I am representing for respondent number 4, 5, 6 and 8, all our apartment owners association, your lordship. Last week itself, your lordship has passed an order stating that in residential apartment, an association under the Karnataka apartment ownership has to be formed. So when we approach the sub-register office, they are not ready to register by stating that there is a PIL pending. There are plenty of directions from this court to register under the Karnataka Apartment Ownership Act. The case of the petitioner is that, Your Lordship, there is one book which is prescribed under the KAOA Act, Karnataka Apartment Ownership Act. It is not kept by the sub-registrar. So the entire deed of declarations, whichever has done from 1972 to till 2024, has to be declared as null and void. There are thousands of apartments or apartment associations are formed under Karnataka Apartment Ownership Act. In fact, Your Lordship, the statute which they are depending on is Karnataka Ownership Flats Regulation Act. Section 3H of the Act, it is very clearly mentioned that it is a builder's responsibility to mention the precise nature of the association which has to be formed. All these, many of the 90% of the builders have mentioned that it is under the Karnataka Apartment Ownership Act. And now they have approached the court by the statute has prescribed certain procedures to be followed. It is very clearly mentioned the deed of declaration in Form A and bylaw in Exhibit B. Format is also given. And the sub-registrars are registering it. And only additional duty is that we have to submit after registration to the Cooperative Societies Registrar, who is the competent authority. That is also complied. Only one thing in the sense, one book which is prescribed section 13, sub-registrars are not keeping that book. If the real intention of this petitioner is to strengthen, that is what they have mentioned in their preamble, the synopsis, is to strengthen the act, they should have approached Your Lordship for getting a direction, a mandamus, to give the government to keep a book before the sub-registrar office. So the intention itself is to nullify the entire thing and to promote something else.
No, that is a simplistic view of only the mechanics of what is happening. As far as the deed of declaration is concerned, we have no problem with the deed of declaration. The deed of declaration can stand as it is. The problem is that deed of declaration is being used as an association, and that is not what is envisaged. And RERA, I didn't hear the word RERA at all. And RERA is the overriding legislation of today. And therefore, this court will have to look into it, that whether RERA comes into play or not. Even the earlier judgment about a fortnight back by this court, RERA has been ignored in para 18 of that judgment onwards. Therefore, that judgment can also stand by itself. It will be OTOs as far as that judgment is concerned, because as far as the formation of the association is concerned, that question will be thrown up, even if the question is asked that, okay, deed of declaration stands, but deed of declaration is not the document. This is, as my learned friend has rightly said, it is a matter of considerable importance. But the importance is there because RERA has been ignored, and under the old regime, where people have been just forming unregistered association without a proper structure. And that structure will be in the form of which organization? It ought to be a body corporate. And it ought to be a body corporate in the nature of a cooperative society or a company. But then again, in view of certain observations, that has to be again viewed as per incurium of the Supreme Court judgment, as well as in ignoring the law. So,
Your Lordship, there are plenty
and
of
one last submission.
and directions from
One
the
last
court
submission.
itself to form under 1972.
No, I just wish
and in verbatim,
just wish to-
actually, in CRP 96, Your Lordship,
we are
Your
not,
Lordship has
not arguing.
We
the
are
matter.
granting all implement applications.
It was just only for that only. Only one thought
Your
I'd
Lordship,
leave.
my
I'd leave
submission,
three
Your
lines,
Lordship,
three lines for the court.
sub-registrars are refusing. Last week, Your Lordship has given a direction to form under 1972. Citing this 511, sub-registrars are refusing to register.
The sub-registrar's role is only to
But
Well,
the state
statute
government has taken a stand.
Your Lordship.
This is not a redundant issue. For this reason, 2 lines, my lord. The state government stand is captured here. It is submitted that the formation of the Apartment Owners Association based on the mere registration of the declaration, thereby claiming them to be a body corporate or juristic body, and opening of bank accounts, opening PAN card, etc., are not as per the spirit of the act. So the state government per se has confirmed what we have said. Then we will argue the case.
My lord, one more grievance. The deed of declaration given by the builders to us apartment owners.
On next day.
Not,
Whatever submissions to make on next. When shall we keep? 1st of August.
please.
Obliged.
In fact, it is covered by your lordship's decision in the last week, your lordship.
One such matter was dismissed.
Right.
With your lordship's leave. These are batch of matters, my lords, where the provisions of 371J and this circulars issued thereunder are under question, my lords. The implementation of 371J. May I just draw your lordship's attention to the order sheets. What has happened is there's a writ appeal connected with these writ petitions. Originally, it came up before a roster pertaining to the administrative tribunal. Judgments were passed by the tribunal against which writ petition was filed. Writ appeal got tagged along. Thereafter, sometimes it is posted before your lordship, sometimes it is posted, my lords, before the roster bench having against the orders of the administrative tribunal. My lords, today also there are about 3 other matters which are posted before court hall number 3. Therefore, my lords, could all of them be tagged along and posted before one bench so that matter can be heard?
You make written submission to register judicial and will pass the order.
In fact, it was posted before your lordships on the 27/5. Your lordships adjourned it to 25/6. On 25/6, it was posted before another court hall.
What are the matters?
Let's.
376J.
371J.
371J.
Please, 371J reservation, my lords. Recruitments has taken place, my lords, in respect by virtue of a common notification in respect of both the residuary parent cadre and the 371J cadre. Now it is only about how the posts have to be allocated, my lords, with regard to that. Based on the different permit, there were different circulars. The tribunal, my lords, in all the challenge where the circulars were challenged and the procedure on the basis of which allotment was done, has, my lords, upheld those circulars, my lords, and dismissed those petitions. As against that, my lords, except 24.1, remaining matters, my lords, relate to that. Except 2 matters relate to school education, where, my lords, around recruitment to more than 10,000 teachers, my lords, is in question. Remaining matters relate to college education, where lecturers post, my lords, of about more than 1,000 are involved. One matter, my lords, 24.1 is the only writ appeal, my lords, which relates to KPTCL, which was filed before a learned single judge. There, my lords, writ petition was allowed, and then certain directions were issued. Only as against that, my lords, but on the last date of hearing, all this batch of petitions were listed in court hall number 3, my lords. And my lords, there are 2 other different batches, but they are in respect of different recruitments.
But issue would be the same. And my lords, your lordships have passed some orders, my lords, on 27/3 and 27/5. The remaining orders are passed by, my lords, other benches of this on.
You move the register judicial and will pass the
Please.
appropriate order.
Please,
On
my lords.
administrative side.
Please. One submission.
4.1, please. For retirement, my lord, and the statute has appeared, my lord, in 24.1 for appellant. The request, my lord, my name be deleted, please.
Will delete on next day will do. Sure.
And 24.1, my lords, where on caveat, we have not been served. There are 13 office objections as well. They have not complied with even court fee. So that may.
We'll do that. So next. Yes, next.
Number 20.
My lord, interim orders may
Five.
kindly be
It
extended.
will be extended.
Number 25.
Extend the interim order.
HR Shori.
Not in 25.
Notice had been issued. A notice had been issued, my lord, but no counters have yet been filed. They supposed to file, my lord, it may have to be filed.
And I pray for some time to file the counter, my lord.
You
My lord,
file
I've
it because
just got, my lord,
the grievance is that there are 11 burial grounds in the vicinity. I've given the details.
My lord, I have filed an application for impediment. It is at my request, my lord, this particular area is reserved. So I am not made a party to this writ petition.
Burial
Reserved for graveyard. my lord.
Lord, my learned friend says that his client made a request to the deputy commissioner to reserve some area for the graveyard. Therefore, he wants to be heard. But actually, my lord, he is not a necessary party at all, because this is an action of the deputy commissioner with the previous permission of the government to be given to the BBMP. So it's not a grant to my learned friend. He didn't say.
So I am
he
not
wants-
claiming a grant or an allotment.
So he
It
is
is
not a
reserved
necessary
at
party.
my request. I made a detailed representation to the deputy commissioner. The deputy commissioner passed an order reserving this area, not granting or allotting for the purposes of burial of Muslim community which are living in that village. So I am obviously a necessary and a proper party. Any order made will not affect us also.
You will give an audience. You will be given audience in the proceedings of the case. Yes, he can, I have no objection if my learned friend wants to assist the honorable court, but what I'm saying is. No impediment. No impediment, my lord, can be ordered.
Because
We'll keep your petition, application pending, and we'll give you the audience.
the application which I have filed in this writ petition.
It will be kept pending and will be entitled to audience.
But if the main matter itself is disposed of, my lord, I'll be affected.
We are not disposing of it. You are filing reply.
My lord, I pray for some time, my lord. My lord, I've just got these photographs. If I could pass it on to my lords. My lord, the contention is being raised saying that there is a Kalyani in the said 1.26.
Let them, my lord, not pass on papers across the bar like this, my lord. This creates confusion. My lord, let them, my lord, file whatever they have to file.
Nothing. I'm not filing it. I'm just bringing it to the notice of the court. I cannot be prevented from showing what is the true facts. My lord, the photographs, my lord, there is no Kalyani there, my lord. There is just a pond, my lord, which is being used for animals. And my lord may see the area in around. I will file these photographs along with my statement.
Lord, I respectfully submit, this is a violation of natural justice. If my learned friend had noticed, my lord, there was a statement made that they will file counter. They have not filed counter. They are passing on some photographs. My client has to see them.
My
Only
lord,
then, my lord, I can say something.
We'll not look into. For
Oh.
those, we are colorful, but we'll not.
Very well.
It can come with the statement of
Better colored
objections.
photographs also.
You come in substance, you file some.
Yes.
Yes. My lord may grant me 2 weeks' time, my lord.
No, we'll not grant 2 weeks. They are very vehement in their case. that-
Very well. My lord may grant me at least 10 days' time, my lord. Lord, I have to get instructions, my lord.
18th, 19th,
19th, my lord may have.
Please.
or 22,
Well,
19th.
no, 22, my lord may have,
22,
because I'll have some time, my lord, weekend.
Lord, they were served in April, my lord. April.
My lord,
Now we
had
are
the
in July and this is an
parliamentary elections,
action.
my lord. We had the parliamentary elections, the officials have to get back. They have got back now. My lord, if my lord could have it on 22nd, I will not move for time.
20.
Obliged, my lord.
Meanwhile, my lord, let them be no burial there.
No, there is no
No,
burial.
no question of that.
That's all I'm
With
saying.
utmost respect, my lord. As far as this pond is concerned and the trees which are in existence, that will not be either cut or the pond will not be closed.
My learned friend, my lord,
But
can't say
burial
any of
can
these
take
things.
place, my lord. There is no
Because he is
difficulty.
not the grantee. The
Allow-
grantee is the BBMP.
Sir,
And the
allow me to
BBMP, my
say
lord,
what
must
I-
be restrained from
I don't
permitting any
understand.
burial. That's all I'm saying.
My
I
lord,
don't
the
understand
ground is
this
handed over
interruption.
to BBMP, my lord. The only this thing writ petition filed is with regard to challenging the order of the Deputy Commissioner Revenue. Pursuant to this order, what I am instructed to state is that it has been handed over to the BBMP. Now, I'll have to get that date and inform my lord that my lord, we have nothing to do with this land after the passing of the order of the Deputy Commissioner Revenue. And that was passed in September 2023.
Let the persons who are dead be buried peacefully. without affecting, my lord, either the pond or the trees there.
They can't be buried there is my question. My lord, my
No.
submission is,
My lord, no cremation is taking place
That-
there, my lord, no burial is taking place.
then
My
that
lord,
can
may
be
have
placed
this
on record. My lord. I have
22nd.
no objection. If they say, the government is saying,
My lord,
no burial will take place till your lordship's here, I have no problem.
Cremation will also, no cremation is taking place, no burial is taking
Not
place.
cremation,
The
only
land is
burial.
in the BBMP now.
may I make one submission? My lord?
Who is for BVM?
I appear for this.
What is the status?
I have to confirm that, my lords, I have no inspection. I'll also file no objections on the 22nd.
No, the council, the Miss.
Yes, my lord, instructions.
It's been told that it's been handed to me.
He is saying that no burial is taken. No burial.
Yeah, my lord, the photographs are there. I wouldn't want to
What is your
mislead.
What is your stand about burial?
I have to get my instructions on that. I'll file my objections along with the
You also file your.
I'll do that.
My lord, unfortunately or fortunately, I am not made a party, but I have already filed objections along with my IA. That your lordship will hear on the 22nd. All that I am going to say is this, my lord, that pond as well as the trees will not be affected in any manner. Their contention is that pond, water in that pond is being used. We can even fence it, my lord, allow them to use that pond. As far as trees are concerned, my lord, not a single tree will be cut. Allow the dead to peacefully get buried there.
This is Kalyani. Kalyani is a
Kalyani is-
temple holy pond, my lord. It's a pond where the idols are taken there.
That's why, my lord, for a
Lord,
bill-
not a dilapidated.
Temple, my lord, a pond where
No, no,
water is taken.
Temple also.
My lord, permit me to say
All
two
the revenue
things.
records show that
Permit-
there is a temple Kalyani pond
No.
there.
No, my lord.
Lord, between today and the next date, my lord, if there is no precipitation by means of burial. That we have not granted last time, you.
Yes, my lord, no. We wouldn't want to disobey my lord's trust.
Unless the proper things come on record, then we'll consider grant of interim.
Very well.
Very well.
You also demonstrate that there is a Kalyani, there is a holy place. Their own record, I produced everything, my lord. All right. Their own revenue records, the report of the Tahsildar says that there is a Kalyani in the premises. It is a Gundu Topu land, which is the land reserved for growing of trees and a pond. How can they give it to a Muslim burial ground when there are 5 burial grounds in the vicinity of 5 kilometers or less?
That is because the first petitioner's land is just adjacent to this. It's a private interest and not a public interest. I have stated that and I will demonstrate before this court on the next date of hearing. And I have produced photographs which, my lord, my friend is also served with copies.
Please see page 142. my lord. Second
Yeah,
Very well.
obliged, my lord.
or 23rd,
No, my lord may have this on 22nd, my lord.
22nd for the time.
It's second ago. My friend.
No, your lordship may fix a date 2-3 days before that for filing counter, my lord. Otherwise, they will come and give it to me on that morning and let the counters be filed by 19th. Of objections shall be filed on or before 16th of. Yes.
My lord, 19th, my lord,
19th.
obliged.
And the copy shall be served to all the sites in advance, 10 or to 23rd then. Please, ma'am.
Can I also get copies in advance?
Yes,
All the
yes,
sites.
I'll-
Statement of objection. So
I
that
will,
I
my
can
lord,
also assist the court on that day. Grateful to you, Lord. 23rd.
26. Anvukappa.
I appear for the two state in this matter. Short accommodation of 2 weeks may be granted, your lordship, in this matter. I appear for the state in this matter of the accused. 2 weeks time may be granted. Your Lordship.
Granted, 7th of August.
Obliged.
Number 27.
I appear for the accused, my lords. I pray for short accommodation to file a counter, my lords.
3 weeks.
This is an impugned order of January 2023, my lords, directing reinstatement and payment of back wages. Even in October 2023, my lords, this honorable court had dismissed their writ appeal
Writ appeal is dismissed.
dismissed by this honorable court
My
and
lords,
he'd already
if I
filed.
may make one submission, my lords, the contempt was revived on the previous occasion, my lords.
No.
Writ appeal was dismissed in
We've
October
preferred,
2023.
we've preferred a review petition, my lords. That is the honorable single
All
judge.
right, but now what about compliance? What about compliance?
All I'm seeking for is a week's time, my lord, to file a counter.
We'll comply with within 1 week.
My lords, if I may pass on the memo, my lords, for partial compliance, my lord, the 25% back wages, my lords, we are ready to deposit before this honorable court, my lords.
Where is the direction?
My lords,
Where are the directions?
directions, my lords, will find the order of this honorable court dismissing the writ appeal, my lords,
Where is?
along with my application seeking restoration of the contempt proceedings, because the writ appeal order was passed after I filed my contempt petition before this honorable.
Reinstate the petitioner immediate effect.
Please. The single judge's order is at page
It is done.
26, my lords.
So appeal is dismissed, review is dismissed.
No, review is pending, my lords. The honorable single judge has given this Friday as the date of hearing, my lords.
So either you obtain order or comply with.
My lords, if I may
They've-
pass on this memo.
They
my
filed a
lords.
review of the single judge's order after the writ appeal was dismissed by this
Sir,
honorable
order,
court, my
judgment
lords.
and order of law on a single judge dated 24th January 23, comma, the following directions were issued, page 34, ABC. The petitioner was accordingly required to be reinstated with immediate effect, and he was to be paid 25% back wages.
Please.
Full stop. It is
My lords, we
stated,
are ready to deposit 25% back.
it was
wages today, my lords.
undisputedly stated that the writ appeal against the aforesaid judgment and order have been dismissed. Full stop. Learned advocate for the respondent, however, submitted that review application is pending.
Yes,
Full
my
stop. Pendency of review application is no ground not to comply with the directions. Therefore, it is provided that unless within 2 weeks, the appropriate orders are obtained in the review application, comma, the directions of reinstatement, including payment of wage shall be complied with, failing which the respondent shall be exposed to aggravated contempt. Stand over to 2 weeks will be, which it stand over to 23rd of,
Very much obliged.
Number 28.
in the meantime, it will be open for the respondent to comply with the order if advised.
Please.
You are paying 25%.
My lords, if I may submit this, my lords, it's,
do it,
the
do it.
DD is in the name of the Registrar High Court of Karnataka.
My lords, deposit after. They were directed to make the payment to me, my lords. Now they are offering to deposit it, my lords. My
You are
respect.
not accepting deposit, you pay them.
Very good.
Much obliged, deeply obliged.
For 28. Preeti case.
For the accused case,
For
my
the
lord.
complainant.
My lords, we received the notice on Friday, on the 5th of July. We would like to take a short accommodation to file a counter after all.
1st August.
Much obliged.
It's about 29.
1999 appear for the petitioners, my lords. This is a PL, my lords, pertaining to the death of the wild elephants, my lords, due to the overspeeding of the trains in the forest.
My lord, I would like to file my objections in this matter, as in submissions, not objections, as to what the state forest officers have done. And this has to be done in coordination with the railway authorities. My lord, if I may place this on record.
There was a PL before the Honorable Supreme Court, my lords, a clear direction has been given that during the night time, the speed of the train should be, it shouldn't be more than 25 kilometer, my lords.
1st August.
My lord, if I can just place this on record.
My lords,
Can I have
may I
this
make one
placed on-
submission, my lords? Mr. Dhananjay Joshi has become a senior counsel, my lords. His name may be deleted from the advocate appearing for the petitioners, my lords.
My lord, if I can have my
Apply to
submissions
this.
placed on record.
Apply to the register. Yes, next.
My lords, a date may be given, my lords.
1st August.
Number 30.
Grateful. my lords.
Shall I have my submission filed, my lord?
Yes, learned Additional government advocate means. Files, what is that?
Copy has also been served, my lord.
Submissions. File submissions which are taken on record with affidavit.
These are my submissions, my lord, on behalf of the forest.
Grateful.
December 30.
My lords, I represent the petitioner's counsel in this matter, my lords. My lords, the matter needs to be heard. Pleadings are complete. The government had filed a report, my lords, pursuant to this honorable court's order. This matter, my lords,
About drinking water.
groundwater PIL, my lords. This connects, relates to groundwater, my lords. Some affidavit has been filed, but it doesn't meet the directions
Take out
given by this honorable court, so I am ready to place in the court.
6th August will take up. Next.
December 31.
For the petitioner, my lords, taking a week's time, my lords.
Week's time, 6th August.
Grateful.
December 32. December 32. And
No Passover.
seniors held up in other.
2nd August.
December 33. Mr. P. Mahe.
I bring for petitioner, my lordship. Seeking for writ of mandamus, my lordship. The last occasion, my lord friend has.
You have filed your
Yes, ma'am.
counter? File it. 7th August. Yes.
Number 34.
Case.
Rajesh Gowda.
Challenging the annexure. G.
Lord, in this I pray for a short accommodation to file my objections, my lord. They are ready. Just have to finalize it.
Sufficient time has already granted, my lord, because thing is that without any allotment, illegally constructing over the property therein, my lord, in page number 60, in 59 onwards, 59, 60, until 67, 63, illegally construction is going on. And the last night also construction was going on, my lord. We challenge in the annexure G,
No urgency.
my lord, because of that. My lord, it's very.
12th August. Sir. Next.
Oblige.
If I adjourn. Next one. 36. December 37. Mr. Saravana, yes.
We have filed our
37.
statement of objections.
Taxi council for 37.
You are appearing 37. 37, you are appearing.
No, taxi council, my lord.
13th August.
Number 38. Ram Shuprakash.
Yes, any urgency?
May it please the lordships.
The senior will argue the matter.
May it please the lordships. In fact, this issue pertains to the removal of the State Pollution Control Board chairman, your lordships.
Lord, we have filed our statement of objections. AG is appearing in this. Learned
My lordships.
Learned AG is appearing in this matter.
Where is it?
Yes, he has been informed to.
AG is appearing. Let him come. Once he comes, we'll take him.
Please.
Please the lordships.
Number 37, interim order request. No, my lord, we have filed statement of objections, not to confiscate the mineral was the order till the next date of hearing. We have filed our objection. Lord, they have no right over the mineral.
Already adjourned.
But there was an interim order benefit, my lord, in my favor.
Extended.
Lord, till the next date of hearing, we have filed our objection. They have no right over the mineral.
Not to confiscate the equipments.
No, not
Yes.
to confiscate the mineral was the order.
No. not to confiscate or dispose of machineries, weighbridge. Fine, stop. I have. ಅದು concession file ಮಾಡೋದು ಅಂತ entry ಮಾಡೋದು ಅಂತ ಹೇಳ್ತಿದ್ರು. ಇಲ್ಲ ಆ ಥರ ಇಲ್ಲ. They have filed objections.
Liberty was reserved to the respondents to seek vacation or modification of the order which they have not done. They only filed their objections, but to say that this was there only till filing of objections is not correct. So I'll file my rejoinder to the statement of objections filed.
Fine, let them. When you will file? 1st August?
Please.
So they want extension, extension. They want extension.
Sorry, Miller?
They want extension. What is this? They want extension?
They want to remove the excavated mineral, Lord.
No, first prayer, let us now. First prayer is what?
We are seeking for extension notes.
Extension for removal of excavated.
Permitting continuation of operation of mining activities for the period it got frustrated on account of impossibility. So otherwise your period is over?
Over.
Period is over, not otherwise.
So
One day they gave us,
he cannot be granted.
It cannot.
Prayer B.
B, even A.
Yeah, my lord.
A, that
1
12
day they
GT
granted. When the statute mandates 6 months period, they granted us 1
That
day.
has
That is
been
our
granted.
grievance.
That has
1
been-
day.
With due respect, that has been granted. We have
I'll file my
taken-
rejoinder and
We
place
have
my.
called out in our statement of objection.
What is rule 12(1)(f)?
12(1)(f), Lord, the lease period may be extended for a period if it is, the mining is not done due to the act of God.
6 months. 6 months.
6 months.
6 months.
1 day they give. That's essentially what we are asking. Right, Lordships, I'll file my rejoinder, my lords.
They cannot avail the benefit of 12(1)(f) because there is no intervention of God in this matter.
I will just be, because it contains both force majeure as well as circumstances beyond control and acts of God.
That's right.
So it is interpretation of rule 12.
Please, my lords, essentially the interpretation of rule.
1st August?
Lordships. Interim order may be extended till then, my lords.
Interim order.
Interim order is a very innocuous order.
Continue to operate till the next day. Stand over to 1st August. Stand over to 1st August in order to enable learned advocate for the petitioner to file rejoinder an interim order. 18, 30.
Number 38.
Okay, there.
My apologies, my lord, just, I was not there when the matter was.
Yes.
But petitioner was appointed as the chairman of the Pollution Control Board. Can you see page 37 of the compilation? Just the list of dates compilation.
How the writ petition is here?
Please,
But actually, we moved the learned single judge. Learned single judge was of the opinion that this has to go before division bench.
Pollu-
Public
pollu-
interest.
There's a circular issued by your lordship, all pollution control board matters, my lord.
This is service matter. This is not
Actually, it
pollution
is
matter.
service.
Actually, it's in
Actually, it is service.
Not under pollution law,
appointment service it comes.
nor the petitioner is creating pollution.
No, but
That's not the
actually-
reason to send it back to single
No,
judge.
no, we moved before the learned single judge. We moved the learned single judge. He was of the
No,
opinion.
they moved it before general miscellaneous court, my lord, not service court. They moved it before general miscellaneous court. General miscellaneous court saw the notification and DB. If your lordships feel, my lord,
Let us see what is the prayer. Let us see.
Our prayer is,
page 32, my lord.
All for the records, certiorari.
assure and quash the impugn proceedings.
So and so, allow the petitioner to discharge his duties and pass direction. What is
Allow
this-
the petitioner to
what is
discharge
this-
law.
What is this notification? Fourth,
31/5/24 is the removal notification. Termination.
removal.
Removal,
So then it's a service matter.
yes.
Please.
My lordships, can I just explain as to why the matter is listed before your lordships? In fact, this matter was listed before the single judge before, because the previous round of litigation was decided by your lordships. That's the reason, okay, the matter
If learned
Take-
single just pass any order, then we'll
Yes,
look into it.
yes, where is that order?
Yes, my lord. Yes, past.
is an order, your lordship.
That
In
is
our
right.
statement of objection, we have produced that order, my lord.
No,
that- that
we have
page-
produced.
Where is the statement of objection?
The Supreme Court.
Your lordships was sitting with Justice.
Page
Dixon.
99.
Page 118. 118 of the statement of objections. 123, I'm sorry, 123 of the statement of objection. Where is this notification?
Divya.
Where is this notification? Okay. Give us soft copy.
What is 22/7/2004?
Can I just give the copy of the notification, Manoj?
The previous round of proceedings, my lord, they reduced the term of the chairman. And that was taken up by the division bench.
Page 42 of the
Connection?
petition is the order passed by this court.
Notification, yeah. Notification.
22/7.
Previous order related to initiation of inquiry proceedings against the chairman and the reduction of his tenure.
So any provision of the Pollution Environment Protection Act is attracted?
Can I give the? copy
Section,
of the notification?
Water Act, Section 6E.
Any provision of Environment Protection Act is attracted?
Section 6(1)(g) of the Water Act has been invoked, my lord, under which he has been removed, my lord. 6(1)(g) of the Water Act. He has been disqualified under the Water Act, my lord. Can I read the notification, what your lordships asked, my lord, which the learned single judge relied upon, my lord? Read the notification.
Reduced or not? 22/7. 22/7.
My lord, can I read the notification of this, which the learned single judge has relied upon, my lords?
It is here.
Your lordship, sir, oh, I'm great. It is a 2004 notification, my lord. It says arising under the pollution control and rules pending NPA. This is under the Water Act, if I may.
Let us see Water Act.
Water Act, I give the compilation.
Section 6.
6(1)G.
This book.
Disqualification, G. So abused in the opinion.
No, it says to take up matters arising under Pollution Control and Environment Protection Act. It does not refer to Water Act
It means,
or service.
it doesn't mean, but
service
it comes
issue.
under,
But what has happened, my lord, in the previous round of proceedings regarding the reduction of tenure, it was taken up by the division bench on the original side. And page 42 is the judgment.
Take up. Please. Any objection?
No, my lord, please.
Since earlier it was.
Yes,
so
no,
annexure
that is
C,
right. that is right.
annexure C, the C is earlier, page 32. This
42.
court had
42.
42, I stand corrected, page 42, my lords.
42.
42. Same petitioner had approached this court, my lords.
It had been taken up before that.
It had been taken up, my lords.
So this arises out of, in connection there.
In connection with that itself, my lords. Same post, my lords.
Now let us see what is the controversy.
Yes, my lord. But kindly see page. But page 35 may be seen. This was my original appointment on 15/11/2021. And this order said that this petitioner has been nominated as chairman of the Karnataka State Pollution Control Board with immediate effect and until further orders for a maximum period of 3 years up to 14/11/24. This was the order. After this, they issued a corrigendum on 31/8/23. It so happened that the new government was formed in June of 2023. This 15/11/21 order was an order passed by an earlier government. As soon as the new government came into picture, they made every sort of possible foray or an attempt to ensure that I am removed from office. And that is evident from Annexure B, 31/8/23. They issued a special corrigendum where they said that, kindly see serial number 6, Lord. They reduced my tenure to 4/3/2022. And there they say, however, with regard to appointment of Shanta Yetimaya, white reference number 4, there has been an error in recording the date of his tenure.
Where you are reading?
That is page 40, Lord. Page 40. 39 is the corrigendum. June 2023, the government changes. In August, they start this. Recommends the intervention in the tenure. Page 40, Lord. Serial number 6 may be seen.
4/3/20, no.
Yes, 4/3/22, 15/11/21 to 4/3/22.
4/3/20.
Yes,
So you are appointed on 15/11/20.
21. Then the same, Lord. Yes. Then they say, however, with regard to appointment of Shant A. Timaya, I'm reading that portion, Lord, below the table. White reference number 4, there has been an error in recording the date of his tenure. Mr. Shant Timaya, white reference number 2, was appointed only for the remaining period of 3-year tenure of Mr. Jairam. However, the date of completion of tenure has been erroneously recorded as 14/11/24 instead of 4/3/22. Hence, the notification date 15/11/21 stands rectified as follows. Then they say, Timaya, so and so is appointed as chairman of Section 4 of the Water Act for a period valid till 4/3/22. This was taken up in challenge before this honorable court, the judgment that we were referring to. And this truncation of tenure was challenged by Dr. Shantimaya and several other writ petitioners.
So this page 40 was challenged.
Yes, page 40 was challenged. Page 42 was the judgment of the division bench.
'96 is the operative portion.
Yes, 96 is the operative portion. Kindly see, there was a challenge to my nomination also. And all that was dealt with in this writ petition. Kindly see two, my lord. Challenge to the selection, nomination, appointment of Dr. Shant Etamaya as chairman of KSPC is liable to be rejected. Page 96.
Page 96.
96.
96.
Yes, I
Thank
think.
you.
96. my lord, 96.
96. The last operative portion of the order. Shall I read that, Lord? The challenge to the selection, nomination, appointment of Dr. Shantamaya as chairman, direction number 2 of the KSPCB pursuant to notification is liable to be and accordingly rejected. The challenge by the petitioner, Dr. Shantamaya, to the corrigendum and government order dated so and so is favored and a writ of certiorari issues quashing the same. As a consequence, his tenure as chairman of the KSPCB is secured till 14/11/24. Now, my lord, in the meantime, what had happened? Since we were litigating this matter, this division bench matter before the court, they issued 2 or 3 notices to me saying that you have committed this misconduct, that misconduct.
They issued notice.
Yes, notice was issued, show cause notice was issued, I had replied. It was standing at that stage. So division bench said, in accordance with law, you can take action. That's what the division bench said. That is at the direction number 4. Petitioner Shant A. Timaya's challenge to the communication dated 26/7/2023, whereby inquiry is initiated against him for the alleged lapses, being devoid of merits, is liable to be and accordingly dismissed. As a consequence, said inquiry shall be accomplished in accordance with law. And what is of importance, my lord, is the inquiry to be in accordance with law. Now, my lord, then the government of Karnataka took interest in challenging this. Yes.
Then what happened?
Then government of Karnataka went on an SLP to Supreme Court. In the Supreme Court, opined that since the tenure was ending in November 2024, we are unlikely, we will not interfere and dismiss the SLPs. So what was of importance was the tenure was safeguarded. It was protected by the court. Otherwise, the government, the executive wanted to remove me and put somebody else in that place. Now, since they could not succeed in this truncation of tenure issue, they started a second round of notices after the judgment of this honorable court. They started issuing notices to me on certain frivolous allegations. They issued the notices. I replied to the notice. They reopened 3 earlier notices and they issued a fresh notice with certain renewed allegations against me over certain issues pertaining to tenders. Now, Lord, what happened broadly, Lord, if I may? Just place it before your lordships. I'll take your lordships in more detail. Broadly, what happened was, so far there were 3 allegations on which they terminated based on the notices. Out of these 3 allegations, 2 allegations are not notices under the Water Act.
Not under the.
Not under the Water Act. Because, my lord, the only termination against a chairman is under the Water Act. There is no other provision. The only method to terminate a chairman is under the Water Act, under Section 6E. And there is no other method of termination. And Water Act specifies, my lord, gross abuse of power and a reasonable opportunity to show cause. This is the gist of Water Act, Section 6C. Now, in the renewed effort to terminate me, yes, my lord, Water Act. Section 6E.
Yes, so abused the.
Yes, has so abused in the opinion of central government as the case may be of the state government, his position as a member as to render his continuance on the board detrimental to the interest of the general public.
So what are the notice? What is the government-
Notices, not kindly see. The first notice was issued on 15/7/23, page 101. Yes, immediately upon change of government,
Page 1.
101. No, my lord, for a moment, why I would not even read this notice is this was not a ground of termination. They did not terminate me under this notice. Therefore, we can leave it, my lord. But I am pointing this out to show how at every stage there was a witch hunt to eliminate me. Therefore, my lord, this page 100 notice can be ignored because, my lord, this notice is not a basis for termination. Then they issued one more notice, 27/7/23, Annexure F, page 104. I'm pointing this out, my lord, to show how they had chosen to intentionally target me. Then, my lord, to this I filed a reply at page 104. Then they left this issue. And then at page 113, they issued a fresh show cause notice dated 27/23. This is the second show cause notice on the issue of nominating Suri Payal as a member secretary. Lord, it so happened, in brief, I'll state, Lord. There was a vacancy in the position of member secretary. Member secretary is like the executive officer who performs and issues all the orders in the pollution control board. So since there was a vacancy, I recommended to the government that somebody must be posted there. Government did not give a decision. In the interim, I had nominated Suri Payal because day-to-day functions had to go on. Then I discovered that Suri Payal was not capable of that office and I removed her. They issued a notice to me on this frivolous issue. They issue a notice to me that you have nominated Suri Payal without the intimation of the government. Therefore, you are liable for, therefore a show cause notice is issued. Interestingly, my lord, at the end of this show cause notice, it is not issued under the Water Act. This is a general show cause notice that is issued. Kindly see, my lord, page 117.
Page
117.
117.
Yes. Yes, here, your act, the last paragraph, your act of deliberately, 117. Deliberately disregarding the rules and government guidelines and acting in an unauthorized manner is questionable. Therefore, you are requested to submit a written reply and explanation within 1 week of receipt of this notice regarding your questionable and unauthorized performance. There is nothing here to indicate that this was a notice issued under Section 6E of the Water Act, which will entitle a dismissal from the post. They have not issued this notice under Section 6E. Then, my lord, what happens? They issue one more notice. Kindly see 27/7, page 118. 118 is my reply. I file a detailed reply to this. Then this is also allowed to subside. There afterwards, kindly see page number 132. This is one more notice issued. That is page 133. And again, the last portion of that notice, 135, may be seen. The last portion of that notice. You move deliberately neglecting the government rules and guidelines is questionable. Hence, you are called upon to submit explanation and details regarding your questionable act and exceeding powers conferred within 1 week from the date of receipt of the notice. Even here, this notice is not under Water Act, Section 6C. Then, my lord, a third notice is issued, page 136, which the translation is found in page 137, making one more allegation. Kindly see page 137, 130, yes. According to the notice issued by Central Pollution Control Board to the State Pollution Control Board and the report of the Pollution Control Board in the government. 138, actually it's 138, sorry. According to the notice issued by Central Pollution Control Board to the State Pollution Control Board and the report of the Pollution Control Board in the government, has instructed to take specific measures regarding violation of plastic waste management rules 2016 and extended producer responsibility guidelines by Enviro Recycling Private Limited, Aravalli Industrial Area. However, even though the Honorable Department Minister in Belgaum has instructed to take immediate action regarding non-implementation of the directions of said letter on behalf of the board, as the said cases of serious nature, you have failed as chairman of the State Pollution Control Board but not taking any action. Providing information along with supporting documents about number of cases pending in the Karnataka Pollution Control Board for the last 2 years, in which prior approval of the government has been obtained. Otherwise, regarding the said omission, I am directed to submit their explanation in writing within 1 week to the additional secretary within 1 week. This is one more show cause notice, again issued vaguely, not under the Water Act, and which is sought to be made as a basis for termination. Then, my lord, what happened? In the meantime, I'm just pointing this out, my lord, to show that how general notices regarding general executive functioning, which were given at one point of time, are being converted into Water Act notices without a statement to that effect or without a charge to that effect. Yes. Then, my lord, what happened? There was one issue regarding they suspended certain environmental officers. Kindly see page 139. They suspended some environmental officers. Upon this suspension, I objected to that suspension. I said, no, they are not liable to be suspended. But they went ahead and suspended them. They went to the High Court and got an order for reinstatement. And then I had to reinstate them. Kindly see page 155, Lord. Impugned suspension order caused by respondent to is hereby set aside. After this, Lord, kindly see, Lord, one point to be noticed. The division bench judgment comes on 31/8/23, where my remaining term is protected by the division bench, permitting them liberty to act in accordance with law on the inquiry. 3 show cause notices were issued by them by then, by 31/8/23. What they do, after they lose before the division bench, they concoct one more set of allegations against me and issue a fresh notice on 29/12/23. This is at page 158. This is the final set of allegations against me. And only this notice is under the Water Act. But this notice, the translated copy is at page 159 or 160. Just one page difference is there. 161 is the translation, sorry. Here, my lord, they make certain allegations. Kindly see page 160. Here, it is clear from the investigation report that you have misused your position and authority and committed the following irregularities and misconduct by violating provisions of Karnataka Public Procurement Transparency Act in activities undertaken to create awareness about environment protection and control. Now, my lord, after me laying down certain allegations, kindly see 163, where for the first time, they say that this is a notice under the Water Act for termination.
165.
165. Upon confirmation, yes, my lord. Upon confirmation that the incumbent chairman of the state pollution 160, I'm reading at 166, my lord, the operator portion. Because all other allegations, my lord, they have been replied to. Kindly see, my lord, 163.
It's 165.
65. Upon confirmation that the incumbent chairman of the State Pollution Control Board has misused his position and authority by committing violation of rules, dereliction of duty, misconduct, and irregularities under 61G, the Karnataka State Board for Prevention and Control of Water so and so is directed to submit a written statement explanation within 10 days of receipt of this notice with reasons why the chairman should not be removed from office. Then I issued a detailed reply of a number of pages. 178 is a translation copy. That may be 178 is the reply. Now, my lord, 3 notices have been issued by them. 2 notices are before the judgment of the division bench, 31/8/23. 1 notice after the judgment of the division bench. The 2 notices before the judgment of division bench do not say that it is a notice under 61G. Only 1 notice issued in December 23 says it is a notice under 61G, making out allegations under Transparency Act. Therefore, what they do later is they combine all the 3 allegations, say it is under Water Act, and they terminate me from service. This is what they do in the final order of termination.
So now which is the impugned order?
That impugned order is at Annexure S, page 255. And before this, my lord, I'll just point out one aspect. Kindly see page 217 before going into the impugned orders. At page 217, Annexure R, they try to conduct a meeting in my absence. The Environment Secretary calls for a meeting of the Pollution Control Board in my absence, though he is not the person who can conduct the meeting. 219. And I move the Honorable High Court of Karnataka on 29th of May 2024. Page 219 may be seen.
So by virtue of this order, you are in service.
No, what I say is, this Honorable Court says that no meeting should be conducted. The impugned meeting proceedings is hereby stayed till the next date of hearing. Because my lord, I was in Mangalore on duty. The Environment Secretary called the Pollution Control Board meeting without the chairman, notice to the chairman. So I was, because this was virtual dereliction of the office, virtual disregard to the office. I moved this Honorable Court. This Honorable Court directed stay of meeting proceedings. This was on 29th May. Perhaps this was a trigger for them. What they did, immediately next day, they terminated me based on all the old show cause notices and replies. Now, Lord, one issue that stands out is, in a case of termination of a person or removal of a person, for whatever is the grounds, natural justice, I'll try to simplify my argument, Lord, because on certain core principles, this order should go. Natural justice means that I should be provided an opportunity for hearing. No opportunity for hearing was provided to me. This is the first ground of attack, Lord, of the impugned order.
No opportunity given at the time of first notice.
First notice, I replied the show cause. Second, I replied the show cause. Even the third, I replied the show cause. But there is no opportunity for hearing given to me. For
Personal hearing.
personal hearing, yes. And Lord, in a case where the Act 6E says, no order, 6(2) says, my lord. I'll just read it. No order of removal shall be made by the central government or state government as the case may be under the section, unless the member concerned has been given a reasonable opportunity of showing cause against the same. 6 subclause 2.
Reasonable opportunity is right to reply.
Reasonable opportunity of showing cause would include, blood.
Would include personal hearing.
Personal hearing.
Any judgment is there?
Yes, blood. That is the
61 Supreme Court or what?
I think 71 State of Punjab versus Erie, blood. Please. Yes, State of Punjab versus KR Erie, 73-1 SEC. Shall I just read, blood, before? I'll just read the.
What is
the-
citation?
Citation is 1973 1 SEC 120.
Page?
Page 120. 120. The question for our consideration is whether orders imposing a cut in the pension should be set aside for the reason that the officers were not given reasonable opportunity to show cause. The law on the point is not in doubt. Where a body or authority is judicial, or where it has to determine a matter involving rights judicially because of express or implied provision, a matter involving rights judicially because of express or implied provision, the principle of natural justice audi alteram partem applies. See province of Bombay versus so and so, so and so. With the proliferation of administrative decisions in the welfare state, it is now further recognized by courts both in England and in this country, especially after the decision of the House of Lords in Ridge versus Baldwin, that where a body or authority is characteristically administrative, the principle of natural justice is also liable to be invoked if the decision of that body or authority affects individual rights or interests, and having regard to the particular situation, it would be unfair for the body or authority not to have allowed a reasonable opportunity to be heard. And then what Supreme Court quotes, it was observed, and finally it concludes. These observations were made with reference to an authority which could be characterized and described as characteristically administrative. It is true that the order is administrative in character, but even an administrative order which involves civil consequences as stated must be made consistently with the rules of natural justice after informing the first respondent of the case, so a case of the state, the evidence in support thereof, and after giving an opportunity to the first respondent of being heard and meeting or explaining the evidence. Therefore, my lord, here what happened, they relied on the report of one Mahadev, investigating officer. Those reports were not submitted to me. I had just made a reply. I was awaiting further hearing from them. In the meantime, because of this trigger of the Mangalore, I had gone to Mangalore, I moved this honorable court, got a stay against the illegal proceedings which they wanted to conduct without me. They took it out on me and removed me by an order. Interestingly, they say, at the last portion of the order, that the 311, Article 311 service law hearings mandated under the Constitution, that is not available to me. They acknowledge the fact that there is a deficiency of personal hearing on their part. And they cite a Supreme Court judgment to that effect. Kindly see that order, my lord. The last portion of the order. Just that sentence I'll take your lordships to. This is at page 330.
311 not available.
Not available. Very well, my lord. If
That is
suppose,
they say.
that is what they say. That means I need not be heard at all. Now 311 goes on a structured framework, my lord. But hearing portion under Water Act 6E.
Which page now?
This is page 328, part 4.
320.
330, 330.
330 part?
Part 4 of that order. Yes. Section 50 of the Water Act.
Where is part 4?
Sorry, Lord, in this only, the last portion of the order, that order as a part 4.
In this
Sorry,
one,
sorry.
page,
Page 330, in that same compilation. Correct.
yes.
330.
Part 4, yes.
330.
Yes, yes.
Yes, here the same, Lord, section 50.
This is order.
This is the order, termination or the ending portion. Section 50 of the Water Prevention and Control Pollution Act 1974 regarding the conversion of members, officers, or employees of central and state pollution control boards as public servants is as follows. Section 50. However, as per the principle enunciated by the Honorable Supreme Court, in the case of S.L. Agarwal versus General Manager Hindustan Steel, 1970 AIR, SC3, the post of chairman of the State Pollution Control Board is not a civil service post, and the chairman of the board is disqualified from being a member of the board. Article 311(2) of the Constitution is not attracted in relation to taking action against them. The distinctions they draw is not that it is not a civil service post. The chairman is maybe a public servant, but it is not a civil service post with a line over the post. But even if 311 provisions, of course, the quotation of this judgment itself is wrong. S.L. Agarwal does not state to that effect. S.L. Agarwal was a case where a person from the Hindustan Aeronautics, a separate body, it was not under a statute. Hindustan Aeronautics Limited was terminated, public sector undertaking. But this is a case where a person validly appointed under statute was being removed. Therefore, Lord, this is answered in Yeri's case. They need not resort to 311(2), Lord. They had to resort to section 6E itself. And principles analogous to 311(2) are always applicable in cases of termination. And then, my Lord, they go about stating. Now, my Lord, the second defect in the order. Where is that? Yes. Then, Lord, I'll come to the substantive portion of the allegations made by them. Yes. Now, my Lord, kindly come to page 314, Lord. There are 3 allegations on which this termination is taken. Page 313 may be seen. Where is part 3? There are 3 allegations, my Lord, on which they terminate me. Kindly see part 2, the second allegation. Part 2, that is page 313, Lord. 313. First ground, Lord, is total violation of personal hearing. This is the second ground. Yes, but in this 313, part 2.
312, man.
312, na?
312.
312.
Page number 312.
312. There is a part 2, Lord.
Part-
Yes. Now, Lord, regarding acting in an unauthorized manner where
Page is 313 here.
313, sorry.
Mine
It's
is
313, I'll change it to 313. Lord, it says,
Sure, part 2 regarding acting and.
yes. And now, Lord, this was the second allegation on which they terminated me. But this, as I showed your lordships, this was not a notice under for 6E of the Water Act. So, if there is a show cause notice given to me in general terms, without stating that it is a 6E notice under the Water Act, how could they convert this later into a 6E notice under the Water Act? This was given previous to the division bench judgment, which had protected my tenure. Now they take, this shows the malified manner in which they have approached. General notices regarding certain administrative issues which were pointed out, which were never connected with 6E and not even stated that it is a notice under 6E, is taken up suddenly in the 30th termination order, in total violation of natural justice. At least I should know, my lord, that this is a notice under 6E, where they are alleging gross abuse, which is not apart from a normal conduct. Gross abuse is something which is extreme.
When
This is-
your tenure ends?
Please, my lord.
November 14th.
November 14th.
14 November.
14 November.
15th of
November.
November. my lord.
November.
Yes, yes.
November.
November.
November. Yes.
Before that. So we'll continue when?
Tomorrow, my lord.
Tomorrow.
Tomorrow.
Tomorrow we'll devote or day after?
Day
Day
after.
after.
Yeah.
Very. 2:30, my lord. Can I see? Please, please.
With your lordship's kind leave, my lord, serial number 57.
Well, at
Serial-
serial number 65.
57, my lord.
Education matter.
Not mentioned.
My lord, serial number 57.
Right. Serial number 65.
Serial
I have
number
mentioned.
57, my lord. Serial number 57.
Serial number
My lord,
48. my lord.
contempt matter.
The date
It's a
may be fixed.
contempt matter, my lords, where
So serial number
the-
48, my lord.
Serial number 60, I'm withdrawing IA, please. Serial number 60.
Serial number?
60, there's IA for early hearing I had filed. Withdrawing that there's an interim prayer which I'm praying, also pertaining to Water Act, please.
Withdrawing.
I'm withdrawing the IA,
IA. This
IA.
is an IA number
IA number 1, please, my
One
lord.
of?
1 of 24.
24. The present IA is for early hearing of the main petition. Learned Advocate Mr.
Shashank.
Shashank. Takes
Shashank Kumar.
permission to withdraw the present IA, thereby giving up the prayer for early hearing. The matter to be listed in normal course.
Well, at serial
My
number
lord, serial
65,
number
I have made
57,
mention
my lord.
in the
Serial number
I
57.
filed application for modification of the order, my lord, wherein your lordship has granted liberty to challenge the order produced by the respondent government predicate during the course of the writ appeal, my lord. But however, that portion of the order was not reflected in the order. Therefore, my lord, I have filed application for modification of.
Whatever.
Because of that, my lord, I am not able to proceed with the taking admission. It is affecting the education institution, my lord. That matter may be kind.
Again, you are bringing the mic nearer.
I'm sorry, I'm sorry.
So what do you want ultimately?
My lord, that liberty is required, my lord.
All liberties are reserved, yes.
My lord, serial number 57, my lord.
77, please. It is for complying of office objections. 2 weeks. 77.
69.
My lord, serial number 57.
Next. 2 weeks.
4 weeks. All.
Next matter in the list.
Serial number 43 and 42, my lords, my interim order will be extended.
Wherever interim order is there, we extend.
Lords, serial number 61. Lords, this matter pertains to, my lords, the appointment of judicial member to the Karnataka State Administrative Tribunal. Lords, this matter is listed today, my lords. May I request, my lords, any date, my lords, convenient to my lords next week.
15. 15.
15th. Lord, next matter, my lord, serial number 39, my lord.
The serial number 47, my lord. So in which Learned AG is appearing. Matter may be taken up at the earliest, my lord, Tuesday or
Whenever.
my lord, there is some urgency in that, may be taken up on 18th, my lord.
18th not. It will go in 2nd August.
18th at 2:30, it may be kindly be taken up. The reason?
Not possible.
Or 19th at 2:30, my lord.
Lord, next matter in the list, my lord, serial number 39.
Yes.
My lord, the
Serial number
very same matter
39, my
is
lord.
before my country.
What is the matter?
Again, my lord, doctrine of pleasure. my lord. At pleasure, at leisure.
In giving dates also the doctrine applies.
Pleasure.
Yeah.
That's the reason.
My lord, serial number 57, my lord.
In fact, they are taking benefit of it and it's getting dragged from past 1 year. That's the reason, my lord. it
We'll
may be
take
take-
up.
Serial number
Your
39,
Lordship,
my lord,
serial
next in
number
the list. my lord.
57.